Good morning, everybody. Happy Thursday, or as Lindsay put it in the chat, Junior Friday. Welcome to TCF Live. My name is Dan. I will be your host as we take the next 4-hour journey through Courtlandia. It is admittedly a slow start in Courtlandia this morning, but we do have Magistrate Chisholm, so let's get going there.
It'll be number one. And when you're speaking with the attorney in the breakout room, court is not a party to your conversation.
There's what I just said to you. You get to talk to your lawyer, and the court will not be listening to you. You're going to go into a breakout room.
Okay.
Mr. Amman? I know I'm mispronouncing your name. What is the correct way to pronounce your name, please? You are muted. There you go.
Daniel Ammon.
Ammon. Okay. Mr. Ammon, we have Mr. Camacho in breakout room 1. And put you with him. Now we've got Mr. Calio.
Good morning, Your Honor.
Morning. We've got Officer Bismack.
Morning, Your Honor.
This is 26 BE 00489. This is a snow emergency ticket that was issued on January 26, around 1:30 in the morning, for the car being parked on Oxford during the snow emergency. You can admit or deny responsibility for that, or you can admit with an explanation. How do you wish to proceed?
I would like to deny the responsibility and provide explanation.
If you raise your right hands, please, to take the oath to commence the hearing. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes, I do.
The officer testify first, please.
Yes, Your Honor. In this case, this was a situation where the defendant can correct me if I'm wrong on this, but in this case, there was a situation where the snow emergency was going to be activated on this particular date. The department had us go out and write tickets on that date starting at midnight. And for the residents of the city, I could see how that could be confusing. The snow emergency starting at midnight, as opposed to our regular 2 to 5 parking. In light of that, I'd like to dismiss the citation.
Calio, the ticket, thanks to the officer's motion, is dismissed. The bond that you've paid will be refunded.
Thank you, Your Honor.
You don't need to do anything to make the bond refund happen. It'll happen automatically.
Understood.
So I can tell you the check will be in the mail.
That's good news. Appreciate that.
See you later. Yes. And this is Officer Borings. Okay. Mr. Emmett back with Mr. Camacho.
Yes, Your Honor.
This is 26-00281, people of the city of Royal Oak versus Manuel Guerrero Camacho.
Good morning, Your Honor. Daniel Ammon on behalf of Mr. Camacho. Mr. Camacho, will you state your full name, please?
Manuel Camacho Guerrero.
All right. Your Honor, at this time, I'd like to waive any formal reading of an arraignment and proceed to a pretrial.
Are you and your client consenting to conducting this hearing on the Zoom platform?
Yes, Your Honor.
Yes.
Plead not guilty, does enter. The next step in the process, Mr. Camacho, will be a pretrial conference. You'll be notified of that conference date and time by mail.
Okay, Your Honor.
Are you still on Freedom Road?
No, I'm not. I give Dan my new address.
What
Your
is
Honor.
his address, sir?
Oh, go ahead. Your Honor, I sent the court a letter with his new address, but he can go ahead and tell you now as well. Go ahead, Mr. Camacho.
Is 21632 Hancock Street, Farmington Hills, 48336.
And Mr. Hammond, do you have his phone number?
Yes,
Yes, I have it. Can you provide it to the court?
yes, it's 248-99.
Thank you.
I'll be representing him
In what capacity?
as
As
his
an MIDC or as retained?
retained, Your Honor.
And that leaves us with bond, please.
Your Honor, Mr. Camacho is a resident of Farmington Hills. He's lived there for the past 8 years. He's been a resident of Michigan since he's 16 years old. He has 3 children, all under the age of 8 years, which he is heavily involved with caring for and supporting. He is employed, and I ask that you just give him a personal bond.
Does he have prior contacts with the criminal justice system?
Your Honor, I don't think he's been in contact since the last time he's been in this court for a ticket was 2018. I believe I represented him then, and I think that is
That's
Last.
my home band, my kids,
Last.
my life.
the last I recall, Your Honor.
Mr. Camacho, the purpose of a bond is not to punish somebody before trial, it's to make sure they show up. You've retained counsel, you're here timely. There's no reason to believe that you're not going to appear at the pretrial. The bond in this matter will be $2,500 personal. You do not need to pay money to stay out of jail to the trial. It's a personal bond. Just appear as directed. Keep in touch with your attorney. And you are good to go today, sir. Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Okay, you can leave, Manny.
Thank you.
Mr. Steinberg. Is Mr. Steinberg be scheduled?
All right, good morning once again, everybody. TCF Live. It is Junior Friday, as Lindsay put it. I like that one. I think I'm going to keep using it. So thank you, Lindsay. As always, a tremendous contributor to the channel here. Let's do this. Let's go to Lake County, Ohio. Judge O'Donnell is getting his day started. This should be a hoot.
With Mr. Franklin, I believe that a knowing, voluntary, and intelligent guilty plea will be forthcoming.
All right. Mr. Franklin, how old are you?
38, sir.
How far did you go through school?
I got my GED.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No, sir.
Have you ever been diagnosed with or treated for any mental illness?
No, sir.
Did you get a copy of the indictment in this case?
Yes, sir.
It's my understanding you're pleading guilty to count 1, having weapons while under disability, a felony 3, and then the remaining count will be dismissed at the time of sentencing. Is that your understanding?
Yes, sir.
Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and understandingly. And I'm going to ask you questions. If you don't understand a question, let me know. If you want to talk to Mr. Fatika some more, let me know that, and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to this charge?
Yes, sir.
You understand by pleading guilty, you're fully admitting your guilt to the charge.
Yes, sir.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
Having weapons while under disability in count 1 is a felony 3. It carries a maximum prison term of 36 months and a maximum fine of $10,000. Do you understand that?
Yes, sir.
Are you presently on post-release control to the parole authority?
You say am I
Are
current?
you on post-release control?
No, sir.
All right. Do you understand that your felony conviction prevents you from owning or possessing a firearm?
Yes, sir.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years as part of your sentence under the parole authority?
Yes, sir.
If you are placed on post-release control and violate any conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, sir.
And if that were the case, the maximum prison term for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
You also understand that if a prison term is imposed, you are eligible for judicial release.
Yes, sir.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 36 months. Do you understand that?
Yes, sir.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand at the time of sentencing, I do not have to follow the recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk with Mr. Fatika before pleading guilty today?
Yes, sir.
Has he discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice he has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions at this point?
No, sir.
Mr. Geigerich, if the case went to trial, what would the evidence show?
Thank you, Your Honor. The facts would show that on September 13, 2025, the defendant was subject to a traffic stop for a speed violation on Warden Road in the city of Wickliffe, Lake County, Ohio. The officer detected an odor of marijuana and alcohol. While the defendant was looking for paperwork in the center console of the vehicle, the officer observed the firearm. The firearm was recovered by the officer. It was a Glock pistol with a loaded magazine. The defendant had previously been convicted of burglary in the Cuyahoga County Common Pleas Court in case 06483-345, which would prohibit him from having a firearm. Thank you.
All right, Mr. Fatika, anything to add to those facts?
No, Your Honor.
Mr. Franklin, did you hear what Mr. Geiger said, that the facts would show if the case went to trial?
Yes, sir.
Are those facts true?
Yes, sir.
What is your plea to count one, having weapons while under disability, a felony 3?
Guilty.
Mr. Fatika? This is the original map. Sign here, please.
Thank you.
Mr. Franklin, is this your signature on the written plea of guilty?
Yes, sir.
And did you sign it voluntarily?
Yes, sir.
Do you want me to accept your written plea of guilty?
Yes, sir.
And I will accept the written plea of guilty. The defendant was present when Mr. Fatika advised of all of his rights, been a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept the plea of guilty and find him guilty of count 1. Having weapons while under disability, a felony 3. I'll refer this for a pre-sentence report. Sentencing will be May 7 at 9 a.m. and the bond is continued. Anything else, Mr. Geigers?
Nothing, Your Honor. Thank you.
Mr. Fatika?
No, thank you, Your Honor.
All right.
Morning once again, everybody. It's TCF Live. My name is Dan. Good to have you here. We'll ride together for another 3 hours and 40 or so minutes, something like that. Let's go down to Fulton County, Georgia. This is their daily calendar. Judge Williams this morning.
Okay. Ms. Brown, your case is 24 CR 006331Y. You're charged with simple battery in this case. You understand your rights this morning? All right, thank you. Mrs. Sirocco?
Yes, Your Honor. For the simple battery position 4, the state's recommendation is time served. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea. And if we could sound for Ms. Clay at this time.
Okay. I'm sorry, what's Ms. Clay's first name? Is Ms.
I
Clay
don't have that in
present?
front of me, Your
All
Honor.
right, is Ms. Clay present? All right, do you so stipulate, Mr. Haddad, and was that your understanding of the agreement today?
Yes and yes, Judge.
All right, Ms. Brown, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge? All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today? All right, and speak as loudly as you can. Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand by taking a plea, you're giving up your right to trial by judge or by jury.
Yes,
And you're giving up your right to have state prove these charges against you beyond a reasonable doubt.
yes,
All right, and the time that you served in the Fulton County Jail should close out your case And do you understand that taking a guilty plea may affect other aspects of your life, such as probation, employment, other open cases, or things your attorney or I may not be able to anticipate? Do you understand that? And are you satisfied with your attorney's representation? All right, as to the charge of simple battery, how do you plead, Ms. Brown? I'm sorry, I need to hear you. How do you plead? All right, I accept your guilty plea. Is there anything additional, Mr. Sirocco or Mr. Haddad?
No, Judge.
All right, Ms. Brown, best of luck to you. Take care. If you don't have other holds or other cases, they'll begin processing you out. We don't want to see you here anymore, all right? Have a good day.
Your Honor, before we move on, how many days are they giving her credit for time served?
Remember,
11 days, Judge.
I'm sorry?
11.
11 days.
11. Is that correct, Mrs. Sirocco?
Your Honor, the state actually can't advise as to that.
Right, and that's what I thought, that we can't calculate the exact amount of days, but whatever time she has served will close out her case. But what was the intended sentence? Let's put it that way, Mrs. Sirocco. What's the
The time
intended?
served sentence.
Right, I understand that, but the number of days that you intend, you have to at least give us, if you,
All right,
you intend for it
yes,
to be
I
a
can-
5-day sentence and then whatever time she would have served. You can't calculate, you're right, you can't calculate the amount that she has served to satisfy, but you can tell us what the time you wish for it to be.
Our recommendation would be serve 22 days.
22 days, okay. Thank you. All right, what do we have next?
Position 62 and 63, Miss Wilson.
Okay, Ms. Wilson, your case is 25 CR 007532C. You're charged with simple battery. In that case, you also have 26 FTA 000523, which was a failure to appear as put on the docket today. Do you understand your rights, Ms. Wilson?
Yes, Your Honor.
All right, thank you. Mr. Sirocco?
Yes, Your Honor. On the charge of simple battery, the state's recommendation is 12 months, serve 24 days. Credit for time served. We're asking for a 12-week anger management. No further contact with Ms. Denise Wiley. Stay away from the Chevron at 6129 Old National Highway in Atlanta, and 40 hours community service. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea, and if we could sound for Ms. Wiley.
All right, is Ms. Wiley present? And Mr. Sirocco, does the state intend to now process the FTA?
Yes.
Okay.
Thank you, Your Honor.
All right, thank you. All right, Ms. Wilson, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge? All right, thank you. And please speak up as loudly as you can so that we can get this down, okay? I'd like this to go smoothly. Are you under the influence of any drugs or alcohol at this time?
No, Your Honor.
Did anyone force you to take a plea today?
No, Your Honor.
Did anyone promise you anything in exchange for taking a plea?
No, Your Honor.
And you fully understand you're giving up your right to trial by judge or by jury? Is that a yes? Yes, all right. What I'm asking is, you understand there'll be no other court dates about this. You're closing your case today, all right? You're giving up your right to have the state prove these charges against you?
Yes.
And you fully understand the requirements as explained to you by your attorney that you're going to serve a 24-day sentence. You're going to take 12 weeks of anger management, have no contact with Ms. Wiley, and stay away from that Chevron, and also complete 40 hours of community service. Do you understand the requirements, Ms. Wilson?
Yes, Your Honor.
And you are satisfied with your attorney's representation?
Yes, I am, Your Honor.
All right. As to the charge of simple battery, Ms. Wilson, how do you plead?
Guilty.
I accept your guilty plea, Ms. Wilson. Is there anything additional, Mr. Sirocco or
No,
Mr.
Your
Haddad?
Honor.
I know, Judge. My records show that she spent 12 days in custody, so shouldn't be time served sentence. Thank you, Judge.
All right. Thank you. Best of luck to you, Ms. Wilson. That concludes your case. If there are no other holds or other cases, we'll begin processing you out, okay?
All right, next we got 2627, Mr. Harris.
Your Honor, position 2627, that's gonna be a plea. The state has amended its recommendation to time served.
Okay.
That's correct, Judge.
All right, Mr. Harris, your case is 22 CR 0000674C. This case, you're charged with battery. You also have a failure to appear docketed as 26 FTA 0000531. Do you understand your rights today?
No.
Thank you. All right, Mrs. Sirocco.
Yes, Your Honor. The state's recommendation on the battery is going to be time served. And for that number, we're recommending serve 139 days, Your Honor. And upon acceptance of the plea, the state will null pros position 27, the FTA.
Okay. I'm sorry, serve how many days, Mr. Sirocco?
100 and, oh, actually, make sure I got this right. Yeah, it's actually going to be 143 days, Judge. We would ask that defense stipulate a factual basis, venue, and ID for purposes of the plea. And we would like to sound for Mr. Anthony Chandler at this time.
So the additional requirements have been erased, including the anger management?
Yeah, given the time served, Judge, we're fine with that in this case.
Okay.
And yeah, so we're fine with that.
And I'm assuming you're also requesting the stay away or no?
Yeah, we're fine with the time served, balance suspended, no further contact, and the stay away.
Okay. All right, I'm sounding for Anthony Chandler at this time. Is there Anthony Chandler on the Zoom call? Hearing none, Mr. Haddad, is that your understanding and do you so stipulate?
We hear, Judge.
All right, thank you. Mr. Harris, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge? Thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time? Did anyone force you to take this plea today?
No.
Did anyone promise you anything in exchange?
No.
And you are fully satisfied with your attorney's representation?
Yes, ma'am.
And you understand that taking a guilty plea may affect other aspects of your life, including probation, employment, immigration, or other things that may not be able to anticipate?
Yes, ma'am.
And you further understand that you're giving up your right to trial. There'll be no other court dates regarding this charge?
Yes, ma'am.
All right, as to the charge of battery, Mr. Harris, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional, Mr. Sirocco or Mr. Haddad?
No, Your Honor.
No, Judge.
All right, Mr. Harris, best of luck to you. Take care. This matter is now closed.
Your Honor, I just want to make sure this is right. 12 months.
Okay, we'll probably visit them again later on, but let's go back up to Michigan. Say good morning to Judge DiSanto.
And Counsel, you're not on your Bluetooth, are you?
can take it out.
No, that's good. I just want to make sure you're not on it.
No, I can hear you loud and clear.
Okay. All right. And so today is the date scheduled in this matter for a probable cause conference on the 26 case and a probation violation on the 23 case. I'm presuming based upon the 26 case. Well, and that there's an allegation that you ingested alcohol, which is the violation of your probation. So, okay. So Counsel, as to the probable cause conference.
Your Honor, I've had a chance to speak to the APA on this matter, both sides. So what I'm asking you to do is I just got on this case. I don't have any of the discovery yet. However, it has been sent. So what we want to do today is I have explained my client's rights. They're willing to waive the 21-day rule. That is my client's desire here today in order for me to review the discovery and just ask that the next date be set as a PCC. So we'll adjourn the PCC to a new PCC day, waive 21 days.
All right, and when did you receive discovery, Counsel?
He just sent it today. So I'm assuming I was with him. So I'm assuming I'll have it by the end of the day uploaded and everything.
Okay, so you didn't have any of it. So because you've been on the case since March 16th, correct?
We zoomed, I think, last week, actually. He was arraigned.
March 16th, actually,
that last week?
10 days ago.
Oh my God.
Was that last week?
I time it, but I have no sense of time anymore from.
Oh, it was last week. It was last Monday.
Yeah, so I mean, Mohammed got to me relatively quickly. I think he probably had to do some stuff to get to go.
All right, so, how long do you believe you'll need to review? Will April 9th be sufficient?
That's what day is that next week?
No, next week's the 2nd. You want the 2nd?
No, I mean, if we do April 9th, would be perfect. I'll have more than enough time if it's April.
Does that work for us, Ally?
Yes, we can do that.
Okay. Adjourn April 9th at 9:15 a.m. And then ask the probation violation counsel, what are we doing with that?
I would ask that be adjourned along with the case.
All right, and your client is currently on an alcohol tether as a condition of his bond on the 26th case, correct?
He is indeed, Your Honor, and he has posted the cash bond as well.
All right, the court's going to order bond and conditions are continued on the 26th case. The court will, adjourn the probation violation hearing as well to April 9th at 9:15 a.m.
Thank you so much, Your Honor.
Bond and conditions are continuing on this as well.
Great to see you guys as always. I will see you either next week or I'll probably have another case, but if not, have a great weekend. Everybody enjoy the nice weather that we so greatly deserve.
Thank you. You as well. Yes, Mr. Gaines, if you're to test right now, what's in your system?
Yeah.
Okay, very good. Thank you. Have a good day. And then we are on the record in the matter of
Attorney Wordy, ladies and gentlemen. Everybody have a great day. Wonderful weather, all that. But he's friendly. You gotta love that. Let's go to Florida. Wade Mercer, first appearances.
Back, so you're here on the charge of violation of conditional release in 26-135 MM. The allegations are that you had contact with your mother in violation of the terms of your bond or release status. Your mother is in the courtroom, and Mr. Mitchell with the state attorney's office, I think, may have an announcement. Mr. Mitchell?
Yes, Your Honor. It was the state's intention after having contact with Ms. Baxley to go ahead and dismiss this case last week. Didn't want to do that until we address the violation of the conditional release. I think probably the best way to go about that is if the court wants to reprimand him on the importance of the conditional release. And then after that's done, I'll go ahead and announce a no information and dismissal in case number 26135 MM, and the victim is in agreement with that.
Thank you. Ma'am, do you have any questions?
Is it gonna be released?
I want to make sure he can hear you, and he probably can't hear you from out there.
I can't hear you.
So when I watched the first appearance video just a few minutes ago, you were in the courtroom, and last week when he was arrested, you came to court, you're the alleged victim. You said you really didn't want him to go to jail, but you wanted him to get mental health help.
Right.
You understand that if the
Right.
state dismisses a charge like you're asking him to do, you can't do both. You can't dismiss the case and try to get him help.
Well, my doctor's giving him help. I talked to him yesterday because I had to go for my blood pressure again.
Okay.
And I talked to him about it. He knows Josh. He's Dr. Josh, and my doctor is agreed to take him.
Okay, do you have any questions about what was happening today?
No, but it's not his fault he violated it. It's my fault.
No, ma'am. It's his fault. He's an adult. You were in court. You heard me say no contact, but more importantly, he heard me say no contact, and there's significant evidence. I think you've admitted you got him out of jail and you let him stay with you. So you're right. It's your fault also, but he's a grown man and he knows he's fixing to find out. He's found out because he's been in jail 2 days. If a judge orders you to do something as part of a case, you follow the order. Now, what you should have done is if you had a medical need, you should have come back to court and said, Judge, we need to modify this condition that you put on here of no contact. No.
How am I going to talk to you when they won't let me talk to you? Because I tried to.
You didn't even try that. He's been at your house over a week. Is that right?
And
So
the
during that week,
doctor's got a note.
before he got arrested, how many times did you call up here asking to modify that? Before he got arrested?
Before he got arrested,
ma'am.
modify what?
Modify the no contact condition.
Well, he didn't get it until he got arrested.
ma'am, before he got arrested this last time, before he got arrested, day before yesterday, how many times when he was out living with you, did you ask to modify it?
But we didn't know. I know
The answer
nothing of
is
the court.
0 times.
Nothing.
You were
court.
stood right there and I told you no contact. He heard me. Okay. So Mr. Mitchell's dismissing the case. We've done everything we can. He's done everything he can. The case is being dismissed. I'm going to direct he be released. I'm not going to keep holding him, but he's got to understand that if he's ever in trouble and a judge says no contact, that means no contact. It's not
Yes,
rocket
sir.
science.
I
Mr. Baxter, do you have any
understand.
questions about any of that?
No, Your Honor. Thank you very
You're gonna,
much.
you're going to be released today, sir. I wish you the best. Thank you for coming, ma'am.
Thank you so
Let me
much.
see. Mr. McDaniel may have something to add. I didn't want to not give him the opportunity. Mr. McDaniel, anything I'm missing? So Mr. Mitchell's going to be dismissing the case against you, Mr. Baxter. Wish you the best. Wish you the best.
We can take him off the arraignment docket for Monday.
Oh, he was on that docket?
Yeah, he was on that docket.
So he's through with the case.
And how do I get the charges dropped? Because he wants to go back to
I
college.
just did it.
Okay. Well,
But, yeah, it's been
there may be a
dismissed.
couple of questions.
There's nothing I have to do.
There's a couple of questions in that. That's a complicated issue. I think, Dottie, help me out. I think under Florida law, recent Florida law, when Mr. Mitchell files a dismissal, there will automatically be a sealing done, or not an expungement, but a sealing. Is that right?
We get a seal on
So I think that under the law has changed recently, but if he wants to be able to say, if the problem is if a job application says, have you ever been arrested? The answer to that right now is yes. If a
Okay.
job application or a school application says, have you ever been charged or convicted, the answer is no.
All right.
The only way to be able to answer that question about being arrested, no, is to have his record expunged, have the arrest expunged. That's a separate process. You need to talk to an attorney about that.
All right.
But he's not been convicted of anything. Mr. Mitchell's dismissed the case against him. You need to understand that, again, it is what it is. You're not in any fear of him, right?
No,
Okay. Do you have any questions?
no.
So you should be able to pick him up at the jail. They'll be processing him out, okay?
At the jail, not at your office?
No, ma'am, because the only reason they come up here before is if it's on conditional release. He's not on
Where's
release
the
no
jail
more.
at?
The Jackson County Jail is on Penn Avenue.
And then-
It's out by, you know where the middle school is at? Where South Street meets Penn Avenue? Deputy Spates will give you some directions, okay?
All right, thank you, sir.
Thank you, ma'am.
Thank you.
Yes, ma'am.
2737 Penn Avenue.
We have Dominic Bremond. Mr.
Good morning,
Bremond.
Your Honor. James.
Mr. Bremond, good morning. Mr. Bremond, you're here because you've been accused of one count of driving while license suspended or revoked. Mr. Bremond, Mr. McDaniel, anything on probable cause on that charge?
Judge, I was just, I talked to him and, I don't know when I guess I'm kind of concerned, when did his license get suspended out of Illinois? Because, he didn't know anything about it. And I don't know if y'all have an out-of-state record that shows, I know he's made some confusing remarks to me. Essentially, he tried to go get his Florida, his license for motorcycles within the last week, and he took the class and, he was doing something with them to try to get his motorcycle license, he says, but, it's kind of, he obviously had his driver's license on him. He says he didn't know they were suspended.
Yeah, we don't have an out-of-state record. I could have asked the clerk's office to run an out-of-state record, and I didn't even think about it this morning. The officer says he double-checked with two different agencies to make sure the Illinois license was suspended, and the Tallahassee Regional Communication Office confirmed it. So I don't know this morning. When we get a copy of that out-of-state record, we'll know why it's suspended. We just know they're saying it is suspended, but I don't know when or why. Florida law requires knowledge of the suspension, so that's a potential issue. He does have for his age, he's got a horrible criminal history, very serious charges and recent serious charges recently as last year and the year before. So that's not in his favor. So what I was going to do is find a probable cause and then see where we went from there and talk about a lower bond than maybe I normally would set if there's no plea agreement. So Mr. McDaniel, anything else on his behalf?
Just some kind of reasonable release option, Your Honor.
Mr. Mitchell.
Nothing, Your Honor.
Mr. Brumman, the criminal history shows some recent stuff out of state. Do you have anything pending anywhere?
I was in a car accident on September 8th with my current girlfriend, which left her with an amputee arm. The charges, it was supposed to be driving without permission, but the charges were dropped. I had permission to drive the vehicle out of Kentucky. I'm still with my girlfriend. My girlfriend is staying at the motel down the street. And we are going to fly out of here, out of Florida, back to Kentucky. And my license, I will take care of it out of Illinois. I'm going to go back to Illinois. I was not aware that my license was suspended. I apologize. I will not drive. And I just want to apologize. I'm sincerely sorry. I do not have any pending charges. I was not arrested. I haven't gone to jail since 2021 for a bar fight that I am responsible for. And I did time served for a bar fight. And I am sincerely sorry, and it's been since 2021.
Now that doesn't match what I'm seeing here. I'm showing a 2025 battery in January of 25, Palos Hills Police Department. Another one, New Year's Eve or the day before New Year's Eve, ag assault, same police department. So you're telling me that's not you? 24.
That is me, Your Honor. Both charges were dropped. Both charges were dropped. I was intoxicated at the time at my apartment, and I had accidentally called the police and had got myself arrested, but I was later released same day and charges were dropped for.
No problem. You just said you hadn't been arrested since 2021, and that's not what the criminal history shows. So you have been arrested. They've just been dismissed. Is that what you're saying?
Yes, and released same day. I didn't do time served.
Are you on any kind of probation anywhere?
No, sir.
What about the armed robbery case in 2022? How was that resolved?
So that was the case. I apologize. 2021 to 2022. It was an armed robbery case. It was the bar fight. How
was it resolved? Is my question. How was it resolved?
Time served and 5 years probation.
Okay, Mr. McDaniel, anything else?
Nothing else, Sean.
I'm going to set you the normal bond I set for this charge for someone who doesn't get a release given their criminal history. Your bond's going to be $2,500, but it's cash or surety. That means you can go through a bondsman. If you go through a bondsman, they're going to charge you about $250 to get you out of jail. We'll give you a court date, and let me give you some more instructions. What court date would you set for, Mr. Mitchell?
The 30th.
Are we after the cutoff? We got to be after the cutoff.
April 27th.
April 27th at 9 a.m. will be your court date. The jail's going to give you a written notice. But listen carefully. If you get your driver's license fixed, Mr. Mitchell, a lot of times, he wants to know that, and he'll take that into account. So if you get your driver's license fixed and you get proof of that driver's license to the state attorney's office, because Mr. McDaniel won't be appointed until that day, but if you get proof to the state attorney's office, Mr. Mitchell very well may dismiss this charge against you, and you won't have to come back to court. But otherwise, you're going to have to be in court on the date I just gave you, and it's a $250 bond. If you go through a bondsman, if you want to put up all $2,500, that's okay too. You do have a condition not to drive a motor vehicle unless you get a valid license. So just to make sure I'm clear, if you get your license straightened out, you drive all you want. But until you get your license straightened out, you've got a condition of your bond not to drive. And if you get caught driving and you don't have a driver's license, that will violate your bond. You will get to use the phone in just a few minutes to try to post that bond and be released. Do you have any questions?
Thank you, Your Honor. Yes. If I post, I have, my girlfriend has cash, $2,500.
All right, hold on just a second.
Get you out there.
Just a second. Let me ask a question. Okay.
Yes, Your
Mr.
Honor.
Mitchell, what's your thoughts on the $250 cash bond, given their lack of local ties and the fact that they appear to have the ability to post that instead?
I have no objection.
Mr. McDaniel, you okay with that?
Yes, Ron.
Okay, so I'm gonna, given your circumstances, I don't necessarily want you to put up $2,500 cash. I know you got to get back home. But rather than you going through a bondsman, I have no problem given the charge, the type of charge you have, of you posting a $250 cash bond. That means you can't go through a bondsman, you can't negotiate with a bondsman, you got to come up with $250 cash. Here's the benefit to that. If the case is dismissed, it's returned to whoever posted it. That's not true if you go through a bondsman. So if you want to post a $250 cash bond, Mr. Mitchell, Mr. McDaniel, and I think that's probably the better course of action, given that you have the ability to do so. Does that work out for you? Your girlfriend posts $250 cash, you're released. If it gets dismissed, the money's returned to her eventually. If it's not dismissed, then it may go towards court costs and fines. Any questions?
Thank you so much, Your Honor.
You're welcome. You'll get your phone shortly to contact whoever you wish and post that bond, okay?
Yes, ma'am.
Troy Gaiman. Mr. Gaiman, good morning. Mr. Gaiman, you're here because you've been accused of 1 count of grand theft, 1 count of burglary of an unoccupied structure, and 1 count of criminal mischief. That last charge is a misdemeanor. The first 2 charges are third-degree felonies. I am the judge that signed the warrant, it appears, so I have read the complaint, but give me just a second because I missed it this morning. I ran out of time. I did not get to remind myself of the allegations. So give me a second to do that. Usually when I read the first 2 or 3 sentences, it'll refresh my memory, especially if it's recent, and it appears to be a very recent warrant. Let's see which case this was. I review a lot of warrants, I should say. Burglary charge, DNA samples of the shed. Okay, I do remember this case. I do remember the complaint. So there clearly is probable cause in the complaint. I'm now looking at your criminal history, which is 30 pages long-ish. And I'm prepared to set you a bond, but I'm going to listen to the attorneys before I do so. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
Nothing, Your Honor.
Mr. Gaiman, you're not on any kind of probation anywhere, are you?
No, sir.
Mr. Gaiman, do you have any charges pending anywhere?
No, sir.
All right, I'm going to set your bond at $5,000 on your 2 felonies. That's $5,000 each, $2,500 on your misdemeanor. Mr. Gaiman, your bond is that's a total of $12,500. It's cash or surety. Cash or surety, Mr. Gaiman, means you don't have to come up with all the money. You can go through a bondsman. It's $12,500 total. We're going to ask the jail to give you a notice for your court date. That will be a felony court date of...
This one's still April 7th, I think.
April 7th at 8:30 will be your notice date. They'll give you that notice in just a moment.
No.
And then somebody's shaking their head. Is that not right? That's the VOP docket. Get down to the bottom part. Yeah, down there where you, April 7th. Yeah. The jail will give you a notice for that date, and you'll get to use the phone in a few minutes, sir, to try to post the bond. If you post the bond, you'll be released. You do have a condition, no contact the alleged victim or that property as part of your bond. Mr. Gaiman, do you have any questions?
No, sir.
Wish you the best, sir.
Thank you.
Yes, sir. Charles Ablitt.
Yes, sir.
Mr. Ablitt, good morning. You're being brought back today. You were first appeared either yesterday or the day before when I was out, and the judge set you a bond. You're being brought back today to meet with Mr. McDaniel and see if we can try to get this case resolved. Please listen to Mr. McDaniel. I'm appointing his office to represent you today.
Your Honor, Mr. Abbott's going to enter a plea of no contest. The charge is listed. The understanding, he'll pay a $400 fine within 60 days, or he'll serve 10 days in the county jail. He has waived his right to jury trial and call witnesses that'll resolve this case today.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Ablitt, did you hear that agreement?
Yes, sir.
Sir, do you have any questions about that agreement?
No, sir. I just want to be left alone.
Mr. Ablitt, is that the plea you would like to enter?
Yes, sir.
Mr. Ablitt, I'm going to accept your plea of no
I'm a
contest.
veteran.
Mr. Ablitt, I'm glad to listen if you have a question now. If you have a question about the plea agreement, I just want to make sure this is what you want to do. Is this what you want to do?
Yes, sir.
Do you have any questions before I accept this plea agreement?
No, sir.
All right, I'm going to accept your plea of no contest to the charge of driving with a license suspended, canceled, or revoked knowingly. I'm going to withhold adjudication of guilt. I'm going to sentence you to 10 days in jail. You will never serve that 10 days as long as you pay the court costs and fines, which are set by state and county law, in your case at $400. So, Mr. Ablitt, you have 60 days to pay the court costs and fines. People a follow-up court date in your kind of sentence. The reason I do that is sometimes things may come up that prevent you from getting this thing paid. It could be a car accident or could be a illness. But if something happens and you can't get it paid, you've got to be back in court on the day after the due date.
I get paid tomorrow, sir.
Okay, just a second. Just a second. I'm going to see if you have any questions once I get through.
Okay.
So the due date, the next day is which? The due date or the day you'll be back in court? May 27th. So you'll be back in court. It's due by May 26th. If you get it paid by the 26th of May, it's over. You don't come back to court. On the other hand, if you can't get it paid for some reason, you need to be back in court May 27th to ask for an extension. And usually what happens is people come in and say, Judge, I got half of it paid. Actually, oh, my calendar's downstairs. What day of the week is that? Isn't that when I'll be in South Dakota? Can I see that color calendar right there? Let's don't give him that date because I need to be here set up because some judge may be doing it remotely. Another judge may be. I'll be out of count. So let's go back. We'll give him one more week, June 3rd. So if you don't get it paid by June 2nd, that'll be the due date. You have to be in court June the 3rd at 8:30 to ask for an extension. That court date is only if you need it. If you get it paid, Mr. Ablitt, you don't come back to court. Lastly, I think Mr. McDaniel said this, but if you can get your driver's license issue resolved, that's going to save you $100. That's really what we would like. If you can get your driver's license issue resolved by June 2nd, it won't be $400. It'll be $300. So I know you said you're going to get it, you get paid tomorrow. So if you can, I don't know what your license issues are, but if you get that issue resolved, then that'll save you $100 on the court costs and fines. So if you can put that $100 towards your court costs and fines, then good for you. But if you need that court date, you've got it. If you get it resolved, you don't have to come back to court. You're going to be released this morning, as long as you don't have any holds anywhere else. Do you have any questions, sir?
No, sir.
Wish you the best, Mr. Ablitt.
Thank you, sir.
Yes, sir. Mr. McDaniel, that's everything I had on my first appearance list. Anything else from the public defender's office?
No, Your Honor.
That completes the day for Judge Mercer. Let's go back up to Michigan, Huron County. This will be Judge Prill.
Lee Lasoski, there are 4 files, 26, 73, 94, 95, 96, and 97 FH. It's time and date set for arraignment. Mr. Lasoski is present, represented this matter by Attorney Dallas L. Rooney. People are represented by Prosecuting Attorney Timothy J. Rakowski. Mr. Rooney, have you received a copy of the respective informations filed in this case? Have you and your client had the opportunity to review them, and do you waive the reading as well?
Yes to all those questions.
Thank you. And it appears there's a plea offer. Is that correct?
Yes.
As best you can, Mr. Lasoski, please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Mr. Rakowski, would you please state the terms of the plea offer on the record?
Yes, Your Honor. In each of the files, there are 2 charges. What our understanding of the agreement is, and what we've offered Mr. Lasoski through his attorney, Mr. Rooney, is that he can plead to delivery of the controlled substance in 2 of the files, dismiss the other 2 files in their entirety, and in the 2 files that he's pleading to the controlled substance, we would be dismissing count 2, the use of the computers. The plea would be as habitual offender 4th offense. Mr. Lasoski would be responsible for restitution, which is the control by money for all 4 cases, even the 2 that we were dismissing. And it's my understanding from talking to Mr. Rooney, we've discussed the guidelines. We understand that the court's not locked into this, but just amongst Mr. Rooney and myself, that we have agreed that the guidelines were 19 to 57. If they're lower, but they wouldn't be any higher than 19 to 57.
So it'd be 2 counts of delivery, 1 in each, at least in 2 files.
In 2 files, and we would leave it to the defense or the court as to which files you wish to take the pleas on.
Okay, thank you. Mr. Rooney, is that your understanding of the plea offer?
It is, and I think there was going to be an agreement that he would be getting time served for the time he's been sitting in jail or prison since March 2nd.
And I believe the bond was revoked in this case when, Mr. Rakowski?
March 2nd.
Okay, so that,
yes.
So that's, I wouldn't say that's a benefit of the bargain. That's just exactly what happened. His bond was forfeited, so he'd be entitled to any credit under the law. Which files, Mr. Rooney, would you be looking at relative to entering the plea on?
They're all very, very similar facts, so I'm just going to pick 2 randomly and give you the dates.
Okay.
One of them was on 12/2.
Okay, that would be 7395.
Another one on November 24th.
That would be 94. Okay.
The circumstances are Very similar.
All right. Mr. Lasoski, did you hear the terms of the plea offer outlined just a moment ago? Is that your understanding of the plea offer?
Yes.
And you wish to accept it?
Yes.
Are there any other terms of the plea offer that we've not covered on the record? Mr. Rooney, do you agree?
I agree.
And Mr. Rakowski?
I agree.
Thank you. Mr. Lasoski, you are not on probation or parole, but you're currently under a prison sentence, correct?
Yes.
And that's in another county?
Yes.
Okay. Have you had sufficient time to speak to Mr. Rooney about all this?
Yes.
Do you need any additional time to speak with him? And you're satisfied with his representation?
Yes.
Is there anything affecting your mind or brain, making it difficult to make important decisions?
No, sir.
You have a clear mind? Thank you. I'll just go in case order and actually be in date order as well. In 267394, you would be pleading to delivery of the controlled substance hydrocodone. And that's habitual offender 4. That is a felony carrying a maximum prison sentence of up to life in prison and or a fine of up to $10,000. Do you understand the charge and the maximum sentence relative to that? In 7395, you are charged with the same offense, delivery of hydrocodone. Again, which is a felony, up to 7 years in prison on or about December 2nd, 2025, City of Bad Axe, County of Huron. You understand that as well. Now understand, if there were no habitual, if this would be your first time before the court, the maximum sentence would be up to 7 years, but because of the prior felonies, it enhances it. You understand that?
Yes.
Okay.
I have a place.
Please. Are these still please or no?
Guilty.
Okay. Thank you. So, Mr. Lasoski, understanding the charges and the maximum sentences. Oh, and by the way, it's discretionary to go consecutive on separate drug counts, or is that law changed now where it's all concurrent?
It says, well, the computer one has consecutive,
Okay.
but the drug ones, I don't see that.
All right, so it'll be a concurrent.
Yes.
Do you agree, Mr. Rakowski?
I agree, but if for some reason it's not, we would agree that we're not going to ask for consecutive sentencing.
All right. Perfect. Understanding that then, Mr. Rooney, as to each of the counts, November 24 of last year, December 2nd of last year, City of Bad Axe, County of Huron, to delivery of hydrocodone. How does your client do?
He's going to plead guilty to those.
Okay. And would you please, sir?
Guilty.
All right. Court is in receipt of an advice of rights form. Mr. Lasoski, it has a signature on it, the printed name Richard Lasoski on it, dated March 26th, which is today. Did you sign this document, sir?
Yes, I did.
Now, before signing it, did you go over this document?
I've gone over it in the past, so I know what it's about.
Okay. Do you wish the court to read the rights into the record? Okay. You understand the rights contained on the form?
Yes, I do.
I'm assuming you went over this form also with Mr. Rooney.
Right.
You understand that by pleading guilty, you're giving up those rights? That means you will not have a trial of any kind nor have any opportunity whatsoever to contest your guilt. And all that remains after today will be for you to be sentenced. If these pleas are accepted, you'll be giving up any claim of these pleas are the results of promises or threats not disclosed to this court during this plea proceeding. You'll also be giving up any claim these pleas are not of your own free choice. Other than the terms of the plea offer outlined on the record, has anyone promised you anything such as leniency to get you to plead guilty?
No, sir.
You understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you in imposing sentence. Do you understand that? Does anyone promise the court will be easy on you? Anyone threaten you to enter these pleas? These pleas are your own free choice. Financial obligations, court costs are due and payable at time of sentencing unless there's good cause shown. Are you aware of that?
Yes.
And that you're subject to a 20% late penalty for any unpaid monetary obligation, court cost that is, due 56 days following your conviction and sentence. Are you aware? Finally, if these pleas are accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeal from the conviction and sentences pursuant to these pleas will be by application for leave to appeal and not by right. Do you understand that, sir?
Yes, sir.
Again, Mr. Lasoski, any questions regarding any of your rights?
No, sir.
Any questions of Mr. Rooney? All right. Let's go back to first November 24 of last year. Were you in Bad Axe, Huron County, Michigan?
Yes, I was.
What makes you feel you're guilty of delivery of hydrocodone?
I said advice for my wife to sell her prescriptions.
All right. And what was the prescription for?
Narcos.
Is that otherwise known as hydrocodone? You had no authority or to do that, correct?
Correct.
Under the law, that is.
Correct.
You know what's wrong?
Yes.
And were the substances indeed delivered then? Sounds like you said you set it up.
Yeah. I drove her around to drop them off.
Okay. And did you see them get dropped off?
Yes.
Okay. Is that what also happened on December 2nd, 2025?
He came to my house.
Okay. And were you in City of Bad Axe, County of Huron on that day? And did you set up this arrangement?
Yes, I did.
And you stated that someone came over and purchased these,
Yes.
and it was hydrocodone?
Yes.
And again, no authority or permission, anything to do so, correct? Were there tests done on the substances, Mr. Lee, or was it just identified visually?
I did not notice a lab test. I think they used pill identifier to look at the shape and the color and the numbers on them.
Any question whether it was hydrocodone or not, Mr. Lasoski?
I knew what it was.
You knew what it was, okay. Mr. Rakowski, any objection to the factual basis?
No, Your Honor.
Mr. Rakowski, you aware of any promises for, oh, wait, to cover habitual offender, I apologize. Mr. Lasoski, do you acknowledge being previously convicted on May 27, 1998 in the Tuscola County Circuit Court for conspiracy to commit armed robbery?
Sir.
Do you acknowledge on April 5th, 2007, you were convicted of attempted resisting or obstructing a police officer again in Tuscola County Circuit Court? Is that a yes? Thank you. Do you acknowledge on October 18, 2012, you were convicted of domestic violence third offense in the 54th Circuit Court for Tuscola County? And being previously convicted on October 7, 2013 of aggravated stalking again in Tuscola County Circuit Court?
Yes.
This would be your fourth conviction, correct?
Correct.
Mr. Rakowski, aware of any promises, threats, or inducements for this plea other than what's been disclosed?
No, Your Honor.
Mr. Rooney?
No, Your Honor.
Has the court complied with court rule concerning pleas, Mr. Rakowski?
It has.
Mr. Rooney?
I agree.
And Mr. Lasoski, there's no agreement made by this court concerning this plea. Is that correct?
Correct.
Mr. Rooney, do you agree?
I agree.
Mr. Rakowski?
I agree.
Court will accept the pleas. They're done freely, they're voluntary, they're understanding and accurate. There's a sufficient factual basis. The pleas are accepted. We'll schedule a sentencing date, Hatch, for
May 18th.
Mr. Rooney.
That's fine, and he has no objection to sentencing remotely.
Mr. Rakowski, do you have any objection to that?
No, Your Honor.
Mr. Lasoski, no objection to being sentenced advisory. Okay. May 18, 2026 at 9 a.m. Prior to sentencing, the court is ordering a pre-sentence investigation and report. Be prepared, provided both counsel and the court at least 2 days prior to sentencing. The sentencing guidelines shall be scored 14 days prior to sentencing and provided to counsel. Any objection to the scoring of the guidelines is filed in writing with the clerk of the court no later than 7 days from sentencing, and a courtesy copy to the probation agent. The defendant must appear via Zoom in this matter for purposes of sentencing. If there's any supporting documentation, either party may submit supporting documentation to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. Bond was canceled and or forfeited previously. Do we need to even address bond?
No.
Mr. Rakowski.
I agree.
Bond remains revoked and or canceled. We will then see you, Mr. Lasoski, via Zoom on May 18, 2026. Thank you, sir. Thank you, everyone. Off the record. Thank you.
Okie dokie, friends. Let's go to Judge Simpson. Say good morning there. Looks like he's got a good game of Hollywood Squares going.
We are in.
Hang on. Right now, I'm muting.
Yes.
Jones, is there a way for you to unmute yourself or? Got it. Okay. State your name, sir.
Derek Jones. And Your Honor,
Thank
I'd like
you.
to talk to you for a minute when you can. Hey, my lawyer.
I'm sorry?
I'd like to let my lawyer know something too.
I didn't catch the last part of what you said. You want your lawyer to do what?
I've been waiting to talk to my lawyer. I had my parole. This case is holding me up.
Okay, I got you.
I understand. I was finally able to get an appointment to meet with Mr. Jones on April 1st. That was the first available date. We have been playing, well, I don't know if we've been playing tag, but finally I got a response.
Got a meeting with him April 1st.
April 1st, yes. I think at 1 o'clock.
So he's.
I went with him yesterday too.
Hold on. All right. So you're looking to adjourn to try to get this solved so that that will clear his way on everything.
Yes, and I have been actively speaking with the prosecutor so that when I go there, I hope to have everything he needs to be done when we come back to court.
Okay, so if you've got an appointment on the 1st, let's do the 9th. That'll give 2 weeks for the writ.
Thank you.
So my understanding, sir, she'll be up there to see you on the 1st. I'm going to adjourn your case out to the 9th. Hopefully we can get it resolved then and move ahead, okay?
Is there any way you can let the parole board know? That way they don't flop me?
That's something you need to discuss with your attorney. I can't.
If you would like, I will write a letter to the parole board and let them know.
Yeah, because I do my parole date is May 26th. So if you can write them a letter, let them know that it'd be on the 9th, be taken care of.
All right.
Thank you, Your Honor.
Thank you. Thank you, sir. Bond continue. Court does call the case of the people versus Stefan Bruce.
Your Honor, David Cook for the people.
Yeah.
David I. Goldstein appearing on behalf of the defendant. Your Honor, my understanding is the defendant is a Wayne County jail. Shouldn't be, but he is. They can't find a tether to put on him. He's been there for 3 days waiting for a tether.
Can't find a tether?
It's Wayne County, Judge.
Oh, okay.
So if we could have
We got them all over the place.
I know you do. You want to loan them? You want to rent one to them? So
Oh. Right. So you need an adjournment on
1 week, Your Honor. Yes. I'm sorry, I didn't do it.
I have to do.
Okay, let me check that.
They'll have to rid him
At the 9th?
still in. Yes. That'll work for you.
Yeah, that's fine.
April 9th, 2026, 9 a.m. I do need to agree.
I'll get you one right.
Thank you. Court does call the case people versus Chidera Kiji.
Your Honor, David for the people. Your Honor.
This is Public Defender Jay Bellinger on all matters not ending in 1678, Your Honor.
Morning, Your Honor. Jonathan Sachs in the matter ending in 1678.
Oh, by process of elimination.
I know you love that.
All right. And where are they? Are they? Oh, they're coming in.
Coming.
Morning. We're looking at spreading rumors you weren't showing. Oh.
Can you state your name for the record?
Chidera Bennett Taikiji.
Thank you.
Thank you. And Your Honor, we are asking for an adjournment today so that we can get Edgy for the health treatment court.
Okay, so you need at least 3 weeks.
I think so. We'll start with that and hopefully we'll have them done by then.
All right, I'll adjourn these matters then to April 16th, 2026, 9 a.m. Bond continued.
Thank you very much. I'll get this in today, okay?
Okay.
Thank you, Judge.
So this is court calls the case people versus Diamond Buyers. Of course she is.
Morning, Your Honor, please.
Good morning, Your Honor. Edward Lucas on behalf of Diamond Buyers in the profile.
You want all matters?
I am.
Are you?
I am as of yesterday.
Name.
Diamond Buyers.
I messed.
Iron was before me, yes.
I know we've been working to try and turn herself on, but
Buyers thought she was going to jail.
I did tell her she wouldn't.
Huh?
Told her she wouldn't.
Told her she wouldn't?
Yeah.
Really?
He had to pay a bond on another matter.
She did.
She had to get arraigned on this case,
And-
up here by on all those.
Except for on 2 other cases, had these other 3,
She had some bond money with her,
really worried.
Yes.
but we are working.
No, you wanna know how I know? She was telling my clerk she was really worried.
Oh,
Was asking them, was she going to jail?
How many times did I tell you you weren't going to jail?
1,000 times.
If I had known that before, she would have gone. No, I'm kidding.
Talk almost daily, and we're looking to resolve these cases, but I think an adjournment would help trying to come to a global resolution.
16th work for you?
That would work, Your Honor.
All right. That objection will adjourn all these matters to April 16th. 2026.
Thank you.
10 a.m. Clerk does call the case People versus Deshaun Jones.
Your Honor, reading for the people.
He should be coming from the back.
Okay. Staffing issues, it's gonna take a minute.
I'll sign.
Your name, sir?
Deshaun Jones.
Thank you.
And Your Honor, I'm asking for an adjournment in this case. We are mitigating. Both parties are working together to try and come to a resolution short of proceeding in the case. So I'd be asking for an adjournment.
16th be enough time for you to get that information back.
That should be enough.
Probable cause conference will be adjourned April 16th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you. Court does call the case People versus Craig Ivy.
Edward Drew, Craig Ivy.
Craig Ivy, sir. Craig Ivy.
We are waiving today, Your Honor. There should be a waiver form.
Sir, you're waiving your right to a preliminary examination? Yes. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
I understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all 3 counts.
Your Honor, I acknowledge receipt of the information. Stay in mute. Waive reading.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all counts. Pretrial will be set for
May 18th at 1:30 with Judge Aquilina.
May 18, 2026, 1:30. Judge Hamoud. Bond will continue. Thank you.
Thank you.
Court does call the case People versus Keontae Jones.
Alexander, Your Honor.
Edward Drew.
Your name, sir?
Keontae Jones.
Thank you.
Your Honor, I was just appointed to this matter. I do not have any body cam or video footage, which I'd be requesting, so I'd be asking for an adjournment.
April 9th.
I was also.
Okay. I'll adjourn this to April 9th, 2026, 9 a.m. Mr. Bond.
These, the defendant's law has clearly said that 45,000 with the 10% provision. At this point, I'm going to be requesting our original request of $50,000 cash charity. Mr. Jones, since being arraigned on March 15th, has made 192 calls completed to the victim.
192.
And I suspect that number may have grown since yesterday, because that was when the most recent set of calls has happened. We've been having a hard time keeping up with the amount of calls that he's been making. So at this point, I'm going to be re-requesting our original request. This case is also occurred when Mr. Jones was on probation out of the 22nd Circuit Court for domestic violence for different victims, along with larceny in the building. And at this point, I have concerns given that he's made this significant number of calls to the victims from his pen to her listed numbers. And I'm going to be requesting the $150,000 cash surety original request, along with his phone and text privileges being revoked to the judge to block her number as well.
Just a short response, Your Honor. What I hear are a number of calls, but I don't hear any of the, I guess, the substance of what those calls are about. So I certainly would be asking that court would at least temporarily stop his.
That he's not supposed to have contact at all. It doesn't matter what he's talking, really. But go ahead, I'm sorry.
No, that's understood. I would like to get a copy, be able to review them prior to addressing them further, but I think taking away his phone privileges is enough rather than raising his bond.
It's a significant amount of calls, a significant amount of connected calls. And the very fact that he's on probation on a DV, he understands. Certainly understands what his bond conditions would be regardless. I think he would have more of an understanding of it. I'm going to grant the people's motion. I'm going to defendant's bond is reset at $50,000 cash surety. We'll get the message. And also his phone privileges as well as texting privileges are hereby ordered revoked. Thank you.
Thank you.
192 calls is kind of hard to ignore. Good morning once again, everybody. My name is Dan. This is TCF Live. Good to have you all here. If you're new out there this morning, say hello in the chat. We're a friendly group. Embrace us. Let's try something new. Oakland County, Michigan. This is Judge Maureen McGinnis. Let's see what she's all about.
Morning, Camilla Barkovic, appearing on behalf of the defendant who is present. Could you state your name, please?
Lamont Hurd.
Mr. Hurd, are you still using a mailing address on West Brockton Avenue in Madison Heights?
Yes, ma'am.
Today is a date and time that's been set for a probable cause conference. How are we proceeding? Judge, at this point in time, I'm asking for an exam date. It's my understanding that the defendant may have waived the 21-day rule at the time of arraignment before I was involved in this case. That's based on his recollection. If possible, I do have another preliminary examination scheduled in this court in the afternoon on April 10th, and I was going to see if the court would allow this matter to also be set on that day.
So I was looking at this, it's a little bit unusual because it looks like he was given an original PCC and exam date, but didn't appear on those dates. So I don't know what happened at the arraignment, how he would have waived.
Is this the one where Ms. Barker submitted a written waiver of the PCC?
Oh, is that, that's what happened. Okay. So I was trying to figure out why I didn't have him here in person at all yet in front of this courtroom, but that's correct. So we did accept that written waiver, that's why.
Thank you, Judge.
So I don't have to address that with him. We can definitely set it for an exam. My only concern is that day that you have the other exam set, I would really need to be done by 3:30. And I was already worried about that with that
Makes
exam
sense.
only.
Understood.
So if you really intend to call witnesses for both, unfortunately, I think it might be best for us to pick a different date. Otherwise, I'm worried I'll bring everyone in, but not be able to handle both matters.
Understood. Judge, could we please do the 16th of April in the afternoon?
We can. There are a number of things that are scheduled on that day, but some things can change. I can put it on that day. Do you know how many witnesses you might be calling, Mr. Piskulovich?
I was thinking of a couple witness exams, I don't expect you to even be.
Okay, well, we'll take a look as the docket gets a little closer, just to make sure it's realistic to manage everything that we've said on it, but for now, I think it's a good date.
Thank you.
Okay, sir, your bond conditions, I just wasn't intending to continue them until I see you again. No issues that were reported to me, so you look like you're doing very well on bond. And we will continue with the conditions that are currently in place, okay? You'll get a court notice at the counter today before you leave if you stop up there after you leave the courtroom.
Thank you.
Thank you. Are you ready? Two 5001689. This is the state of Michigan versus Lamasia Davis.
Morning, Your Honor. Amanda McLean appearing on behalf of Ms. Davis, who is appearing via Zoom.
Could you state your name, please?
Lamasia Davis.
Are you still using an address on Long Creek Court in Inman, South Carolina?
Yes, ma'am.
Today is the date and time set for a probable cause conference. How is your client proceeding?
Your Honor, at this time, we are respectfully requesting another probable cause conference. I was just appointed on the case just a couple of days ago, so I haven't been able to have a meaningful conversation to review discovery with my client. I did tender it to her yesterday. So we were just asking for another date so we can have more time to review that together.
All right, has your client been advised of her right to have her exam begin within 21 days of her arraignment date?
She has, yes.
And she's willing to waive that right?
Yes, Your Honor.
Ma'am, do you understand that because you've been charged with a felony, you have the right to have what is known as a preliminary examination here at the district court?
Yes, ma'am.
You also have the right to request that this hearing begins within 21 days of your arraignment. We've already set an exam date for you next week in the afternoon on April 2nd to ensure your hearing can start within that time frame. Did you hear what your attorney has requested about setting another court date like today's date?
Yes, ma'am.
In order to do that, you would need to waive your right to have your hearing begin within 21 days of your arraignment date. Are you willing to do that?
Yes, ma'am.
I will accept the waiver. We'll take the exam date off of the 2nd. This case is somewhat problematic in that I'm not sure how it got set for a Zoom arraignment to begin with. I know you know the backstory. The problem that I have now is that your client has continued to make requests to appear via Zoom. They would not automatically be granted. Now that you are appearing on her behalf, if you need to make a request to appear via Zoom, we can address that, but I can't accept them from your client directly.
Understood.
So I'm sure she'll have an opportunity to discuss that further. We can set this for another Zoom probable cause conference. I don't object to that.
Okay.
But if you speak with your client once you get the discovery and her intention is to set an exam, please be advised that when we pick a date, she will be here in person and there will be no exceptions. She also has to be fingerprinted, which is why the arraignment never should have been set on Zoom. So we need to come up with a plan to issue an order for her to be fingerprinted, which can only be done in the state of Michigan. So I don't know if that's something that you'll have a chance to speak with her as well on. I can set it out for a period of time, or we can wait to see what's happening at the next PCC and then issue an order, but I have to issue the order and she has to be fingerprinted.
Understood, Your Honor. I think at this time, it might be best to figure out what we're going to do at the next probable cause conference.
Okay.
We were going to request that the next hearing be via Zoom as well. And I understand that the court typically holds preliminary exams in person as well. So that is going to be a conversation that we are going to have going forward if that's the route that we were going to take. I know that there's a little bit of financial difficulty with my client being able to appear via in person. But we may have to address that. But now I hear the court that there is going to be no exceptions if there is a request to have an exam via Zoom.
Yeah, I mean, there really wouldn't have been an exception anyway. We're working through this issue, I think. But she contacted the clerk's office and requested a Zoom arraignment on a felony, which was probably not the best way to handle this case and get it started. So then she would have full understanding of the requirements of participating in the proceedings. But the case is moving forward now. I have no problem with her appearing via Zoom now that you have been appointed and you're making the request on her behalf. Obviously, she appears to live out of state, but she has to get fingerprinted at some point and will be required to come back to the state of Michigan to do that. And then obviously any hearing that takes place that has testimony that would be required, she'll be here in person for that as well.
Understood.
The bond conditions that were set, looks like she was given pretrial services supervision and she's checked in as directed. They went over those initial conditions with her, and I think she completed her first check-in, so no issues with bond, thankfully. I'll just ask that she continue to check in as directed with pretrial services. We can set this out for a couple of weeks and just put it on a docket. Since you know she's going to be appearing on Zoom, if you need to do the same on that day, that's fine.
Okay, thank you.
All right. Is there anything else we need to address today?
Were we gonna pick the date of the counter? Or-
They'll probably just issue it based on what's available. If you have a date that you would like, you can make that request out there. I'm not.
No, that's fine.
a
If it's
Thursday
within
morning.
the next, between the next 2 to 3 weeks, I don't have anything on Thursdays.
In the morning?
Yeah.
Okay, great. That'll be perfect.
Okay,
Thank you. All right, you're all set, Ann. They'll send you your notice in the mail.
Okay, thank you.
All right, friends, so that's Judge McGinnis. If you haven't already given me your vote on how you like her, be sure to do that in the poll that's in the chat. But let's go to somebody who's become the new crowd favorite, Judge Aquilina.
This is docket 253725 FH, people of the state of Michigan versus Anthony Rashad White. Counsel, your appearance for the record.
Good morning, Your Honor. Robert Ioni, Special Assistant AG on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. White. Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury? Thank you. Put your hand up. You taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
And have you had enough time to speak with your attorney?
Yes, ma'am.
I understand there's going to be a plea today, is that correct?
Correct.
And are you a U.S. citizen?
Yes.
At the time of the offense you're pleading to, were you on probation, parole, or bond conditions with another court or this one?
Just this one.
Okay, and when you were on bond conditions on this file, was there
Yes.
another file?
No, ma'am.
Okay, just making sure, because I have to look at all the ramifications as a result of the case that you're fully informed, all right? All right. And you still reside in Battle Creek and Laura? And you're employed?
Yes, ma'am.
And what do you do?
Right now I'm just doing the DoorDash.
Gosh, okay. On behalf of the people, what is the plea agreement?
The defendant will be pleading guilty to count 1, Your Honor. Count 2 will be dismissed. There is a recommendation of no upfront jail, providing the defendant is paying his child support. People will seek reimbursement for prosecution costs. In this case, extradition from the state of Nevada, the amount of $4,618 that will be subordinate to child support restitution.
I'm sorry,
4618.
18. Okay, but that will be paid after the child support, is that correct?
And given the size of the marriage, in this case, it's unlikely we'll see that money.
All right. So, sir, you no longer live in Nevada?
No, I was only in Nevada just helping my mother because she's been sick, but I live here in Battle Creek, Michigan.
Okay, got it. Thank you. Is that full, fair, accurate, and complete? It is, Your Honor. Full, fair, accurate, and complete survey?
Yes, yes, Your Honor.
All right. And counsel, you will be reading count 2? We are. As to count 1?
Can I get to read the information on her?
Yes, sir.
People of the state of Michigan versus Anthony Rashad White. People allege that on or between October 1 of 2018 and February 29 of 2020 in the city of Lansing, county of Hingham. The defendant did not pay child support for his child in the amount or at the time stated in an order entered by the Hingham County Circuit Court, file number 2012 00041 UN. This is contrary to Michigan Compiled Law 750.165. This is a felony punishable up to 4 years in prison and or a fine of $2,000. Or shall order the enforcement to collect DNA identification profiling sample before sentencing or disposition if this has not already been done. The outstanding arrearage as of June 20, 2024 was $191,682. For the record, the current arrearage is $226,291.
Thank you. Sir, did you understand what was just read?
Yes, Your Honor.
So you understand count 1, that child support failure to pay is a felony punishable by 4 years and or $2,000?
Yes, Your Honor.
Now, were there 2 files or 2 counts because there were 2 children? Is that correct?
I believe it was 2 different time periods, Your Honor.
Okay. All right. I just want to make a record that this would be for the full time period, just it being count 1 would also incorporate count 2. So the time period technically would be October 1st, 2018 to December 31st, 2023. Is that correct?
The count that he's pleading to only covers a particular period of time.
Right.
Obviously, the entire arrearage is the entire period for which he.
Right, but this is akin to dismissed files. Even though they're dismissed, someone would still owe the restitution. He still owes the child support, even though he's pleading to count 1. So technically, the child support is owed from October 1st, actually to today's date.
That's correct.
I just want that to be for the record, so there's no mistake on appeal saying somehow you didn't have notice. I'm not saying you would do that, sir, but we see it all the time, and we're a notice state. We are required to provide you notice of all the ramifications of your plea, which would include paying child support from the time the arrearage began through today's date and beyond until it is paid in full. Do you understand all of that?
Yes, Your Honor.
And you still want to go forward with the plea?
Yes, Your Honor.
All right, thank you. It looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And if you had any questions, you were able to ask those of your attorney?
Yes, Your Honor.
And you decided to plead to the count as we've discussed after consulting with your attorney?
Yes, Your Honor.
And you're pleading of your own free will?
Yes, Your Honor.
No one forced, threatened, or coerced you to plead?
No, Your Honor.
And you've been satisfied with the representation of counsel?
Yes, Your Honor.
As to count 1, failure to pay child support, how do you plead?
Not guilty, or guilty.
Which is it? Just for the record, since you said both, guilty or not guilty?
Guilty, Your Honor.
And sir, you understand that by pleading guilty, you are giving up your automatic right of appeal. If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal. And now it becomes their decision whether your issues are important or not important. Had you had a bench trial or a jury trial, they'd have to take a look at your unhappiness regardless of whether they agree with it or not. They get to look at it, but now it's their decision. Do you understand that?
Yes, Your Honor.
You're also giving up your presumption of innocence, holding the people to their burden of beyond a reasonable doubt, putting up a defense, bringing witnesses, remaining silent without them having used, without that being able to be used against you, etc. You understand all that?
Yes, Your Honor.
All right, thank you. Other than the agreement, has anyone told you what I will do at sentencing? Has anyone told you what I will do?
Oh, yes.
Has anyone told you what I will do at sentencing other than the agreement you all made?
No, Your Honor.
They could not have, because I'm not fully informed, I will make up my mind, yeah. It's just to make sure no one's promised you anything, all right. All right, and Sir, there is a recommendation for no upfront jail. That's an agreement with all of you. If everything goes well and I gave you some upfront jail, I would allow you to withdraw your plea in this manner and again go to the pretrial stage. However, if you violate the law or bond conditions, I do not have to honor that. I do not have to allow you to withdraw your plea. Do you understand that as well?
Yes, Your Honor.
All right, thank you. Sir, did this offense occur between the dates of October 1st, 2018 through today's date?
Yes, sir.
You failed to regularly pay child support?
Yes, Your Honor.
And that was in docket 2012-41 UN.
Yes, sir.
And you understood that you had, is it a child or more than one child?
Just one child.
One child, okay, and you understood that you needed to pay child support.
Yes, Your Honor.
And at some point you just stopped paying child support or didn't pay enough child support. So we ended up as of June 2024 with an arrearage of $191,682.
Yes, Your Honor.
And it's likely more today.
Yes, Your Honor.
All right, and you knew that that was payable to the Ingham County Circuit Court, and then the court would credit you for the amounts paid and be paid to the mother of your child.
Yes, Your Honor.
All right. On behalf of the people, any additional questions?
No, Your Honor.
On behalf of your client, any additional questions?
No, Your Honor.
Are counsel aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Has court complied with the court rule?
Yes.
It has.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count one will enter, count two is hereby dismissed, and I see that the people have given me a nollie cross in regard to count two. Court is signing that. Thank you for providing that. If there are any outstanding warrants related to this file, those are hereby recalled and dismissed. And defendant is on notice that there will be not only this money owed, but also the reimbursement for extradition. Do we have a sentencing date?
June 3rd at 10:30.
Does that meet with your schedule, counsel?
It does, thank you.
All right, sir, you'll need to make and keep an appointment with probation. The phone number is on that sheet there that your counsel is going to hand to you. It's 517-483-6100, but the best thing to save you a lot of time of dialing and being unhappy they don't pick up the phone is to, while you're in the building, just go downstairs and make that appointment and keep it. They're going to do a very detailed pre-sentence investigation report, which I have to have before I sentence you. And your attorney can direct you further. They'll need to read that before sentencing. We'll all talk about it. And bond conditions are continued. Is there anything else we need to address, counsel?
We did not, no, Your Honor, it's fine. Thank you very much.
No, Your Honor.
So is your DoorDash, is it full-time?
Yeah, well, yes, because my fiance, she's pregnant, so she can't do anything right now, so.
So she's driving you?
Yes.
Okay, do you have a license?
No.
Okay. Can you get a license or no?
I think I have to pay, I'm not sure, I can look into it to make sure I get it.
Well, because once she has the baby and maybe if she gets farther along, she might not be able to drive,
Correct.
so. Sir, I don't know, where else have you worked besides DoorDash?
I worked at Shippers, it was a factory, and what I'm gonna do after this is actually try to go back there too, so I have a second option available.
I was just gonna suggest, you need a couple things, you need a second option, you need to work full-time plus.
Right,
I mean, you're giving a baby, that's not cheap.
correct, Your Honor.
And do you have health insurance?
Yes, Your Honor.
Is that through the county or state?
Through the state, Your Honor.
Okay. Do you have a retirement?
It's
Probably no. You need to get a job, you certainly are capable. Get a job where it has benefits. You not only have this child you have to pay for, but a new one, and I'm assuming you wanna retire and not be homeless.
correct, Your Honor.
Once you get your act together, how old are you?
36.
It's time, sir.
Yes, Your Honor.
Okay?
Mhm.
So you started applying for some better jobs. If you need help with that, we're gonna do that on probation, but you start working to figure out what kind of job you want. I think you need a job with benefits and vacation pay,
Correct.
family leave time and all of that. And you're already behind and put away for your retirement, so let's get going on all of these fronts, okay?
Yes, Your Honor.
All right, we'll talk more about it, and certainly probation will. And please go downstairs and make your appointment. Spot my conditions are continued. Thank you. Judge.
So just to summarize, $100 and some odd $1,000 behind on child support, and he has another one coming with a different lady. Okay. People make their choices, don't they? Let's go to Texas. Say good morning to Judge Stevens. Or not. Oh, man. It never ceases to amaze me. You know, we try to switch to a court, and just as soon as I switch, they delete the stream. At least a couple times a week. Let's try Judge McNally.
Just had the same charge as him, so I thought it was.
She didn't have any priors. I don't know what to tell you. Trevette, full land Trevette, 25F 244-791. Morning, your name? Raise your right hand, please. Somebody swear affirm under penalties of perjury the testimony you're giving these proceedings to the whole true self to you, God.
Yes.
Did you do all your community service?
No, I didn't do the 2 days. They marked it down that I did it, but I told the prosecutor I didn't.
All right, I'm gonna have to check on this. Have a seat, okay? Thank you. All right, John. Adriana Paliaview, 260-647-413. Find the lawyers, all these lawyers.
Good day, Your Honor. Robert Curry appearing on behalf of Miss Adriana Paliaview. Judge, the people in the back told me you were going to charge us anything and you were going to buy us a dinner at Outback Steakhouse.
Yeah.
Judge, we've sought relief to set aside the default. I don't know how this got lost in the system. Your office granted the relief. We spoke with the prosecutor. The prosecutors agreed, given my client's driving record, to either give me blockading or impeding. So you tell me which one. And it's a non-abstract
impeding here. That's
okay.
Fine. I'll set aside the default judgment. He's doing that by implication. He didn't address that, I don't think, on the stip form here, but I'm gonna go ahead and do it. And
thank you, Your Honor.
Did they post a bond on this one, Heather?
I don't believe so, Judge. I
Let
think
me
we
take
just
a
filed a
look, Judge.
motion.
I think we just did it on attorney's motion.
Fair
No,
enough.
there's no bond.
Fair enough. Okay, to the charge of impeding, responsible or not responsible?
Responsible, Your Honor.
Yeah, it was just an internal issue, right?
Yes, Judge.
All right, good enough. 150 is your total. I'll give them a week to pay. Give them till April the 2nd. Actually, yeah, 1 week to pay. Okay, is that gonna do it?
Your Honor, give me 2 weeks just because I want to make sure between the holidays and everything else.
4/9 at April 9th, okay?
Thank you, Judge. Enjoy your
Thanks.
holidays. Peace.
You too, thanks. Searcy. Jalen Dominic Searcy, 26T-647-832 A and B. What kind of case do you have? Is it going to formal hearing?
No.
What's the name of the defendant? Okay, sir, I'm gonna ask you to have a seat right there, right now, okay?
Me?
Yes, sir. Adam Adamatala, 216-647-736.
Your Honor, Roman Fitzgerald, you have listed all.
All right, you're gonna plead to impeding
That's correct. Yeah,
Res-
that's all it is.
to that charge on his behalf, responsible or not responsible? All right, he's got to slow down here, all right? I mean, it's getting a little 185, and I'll give him till the 2nd, okay? Is that enough time?
Probably 2 weeks.
All right, I'll give him till the 9th, but tell him to slow down, okay? Thank you very much. Who do you have?
I'm here. Use your feel ready.
Who do you have, Mr. Mays?
I've got Jalen Ross and Michael Wright.
All right, give me 1 second. I'm gonna take Fioretti first. Anthony Joseph Fioretti. File number 2-6G306834.
Good morning, Your Honor. Record James Schlaf, 30720.
Okay. Your name.
Anthony, if you're ready.
This is going to be a plea to operating while impaired. They're going to dismiss the super drunk. True?
Yes, it is, Your Honor.
Is that what you want to do?
Yes, Your Honor.
All right. If you plead to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all 4 points. License suspension or revocation in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. You understand that?
Yes, I do, Your Honor.
Did you sign, read, and understand the advice of rights form here today?
I did, Your
If you
Honor.
plead guilty, you will be giving up all those rights, and there will be no hearing or trial. Do you understand that?
I do,
You
Your
have a
Honor.
charge operating while visibly impaired. How do you plead?
Guilty, Your Honor.
Be operating a motor vehicle in the city of Gibraltar on Wilson near North Gibraltar on December 7 of 25 at 11:16 p.m.
I did, Your Honor.
Did you drink alcohol before?
I did.
What did you drink and how much?
Beer.
How many?
At least 1,000 sucking water.
What else?
Yeah,
Shots?
a couple shots, yeah.
What kind of shots?
Would have been Jameson, whiskey.
And you were involved in an accident?
I had tried to do a U-turn and I landed on the rock. Your Honor.
You had,
He was in a parking lot too.
you think that this happened at least in part because of your alcohol consumption?
Yes, Your Honor. Yes.
Was this a blood draw? It was. Do you stipulate that this reading was accurate? 0.367?
Yes, Your Honor.
Are you on probation or parole?
Pretrial services, I have an alcohol tether. After this, I had asked for it.
No. I'm asking you right now, are you on probation or parole?
No.
What about Monroe?
Monroe, it's pretrial services, it's being dismissed, it's being dismissed no for second.
I don't,
What kind of case is that?
It's domestic.
Anybody force you to plead guilty or promise anything to induce you to plead guilty?
No, Your Honor.
Did you ever have a prior alcohol related?
2019, Your Honor.
He better get into the sobriety court that I have, or he's going to jail.
this is what you mentioned last time.
Good, I'm glad I'm consistent.
He has, been in treatment, he's been going to AA as well, but, however, he needs to get into sobriety court, he's ready to do that.
Yes, Your Honor.
Did you get printed on this case yet?
I did. After the last case, I went up to.
You ordered him last time.
Who's Thomas Fioretti?
That's my father.
So he's going to get into sobriety court?
I'm not quite sure the mechanics of that. Is that something that goes through probation?
Here's what will happen if you want to do this. And I'm not threatening you, I'm just telling you with this breathalyzer, blood result, I should say, and you having a prior, you're going to go to jail if you don't get into sobriety court.
I understand, Your Honor.
Sobriety court, we put you on bond conditions today. You'd immediately get a SoberLink device. You'd immediately start testing at your own expense right now. 3 times a week. You'd immediately get into treatment. You'd be going to AA, 3-4 times a week, like I ordered you to do before, right? I ordered 4 times or any combination of treatment and AA.
He has been doing that via Zoom. He has notations of that.
I thought I told them in person.
I
I did say in person. I wrote it down even. I don't know why these guys don't listen. Why haven't you been going in person?
Your Honor, I have a 50 to 60 hour week at work, and I have my daughter 4 days a week.
I told you, did I not tell you to go in person? I know I did. Don't waffle on me. I mean, you got a problem here, son. No, I mean, no disrespect.
I understand, Your Honor.
I don't know why I have to repeat myself and people just change their own, make their own orders. I mean, you can put on the robe if you want. I mean, I guess I could come over there. You can. I'm gonna let it go this time. I'm not gonna let it go again.
Thank you.
So let me finish now. You'd be going to AA, NA, in person. You'd be in treatment. You'd be testing 3 times weekly at your own expense. You're on the SoberLink at your own expense. You'd have to come and meet with probation every other week, and you'll meet with me at a status review, either at 7:30 in the morning on Wednesdays or 3 o'clock in the afternoon on Wednesdays, but I'm gonna move that afternoon session to Tuesdays come May 1st. So you can either come Wednesday morning or Tuesday afternoon, starting in May. We'll put you through a bond phase. If you're compliant, we think you're serious about getting yourself some help, we'll accept you to the program. Our grant funding will be used to pay for your testing, to pay for your sober link. If you have any deductibles, we can help you with that if you're not able to afford it. So at any rate, that's your options. And I'm gonna presume that you're going to go into sobriety court.
I am here.
Okay, good. Sobriety court, but I don't want people in this that are just doing it either for a license or to stay out of jail. I gotta tell you, I've run this program. I'd rather do 90 days than go through sobriety court myself. I would. But that's not the point of it. The point of it is to get you some help so you don't kill yourself or kill somebody else. You get another one in the next 68 years and it's a felony.
Yes, sir.
Okay? So Heather, I'm gonna take a date about 5-6 weeks out, okay?
Will it be one of my council days?
Yeah, we'll give you a date on that. So about the end of April, I'm gonna say early May, maybe.
We have Gibraltar here on May 7th.
How about that day?
Is it a Thursday?
Yes, it is.
That'll be fine.
May 7th at 8:30, okay? But you gotta go meet with probation. Give this a lot of thought, even if you change your mind. I'd rather you come and tell me now than start the program and fail it.
I'm fully committed to the
All
program.
right, well, that's good. Okay, good enough. Good luck. Go down the hall, get your notice, then go meet with probation.
Thank you for your time.
Thank you.
Thank you.
All right. Michael James Wright, 260-647-6908 B and C. Morning to you.
Good morning, Your Honor. William Mays, on behalf of Mr. Wright.
Mr. Wright, your name?
Michael Wright.
Okay, so we have a no trailer plate, serious safety defect, no medical waiver card. File C is the misdemeanor. Does he stand mute, waive formal rating?
Yes.
Not guilty, pleas entered. And then, as I understand it, he's going to plead responsible to defective commercial vehicle. That's file, the serious safety defect, is it? File count 1. And he's going to plead to failure to properly display, failure to attach plate. And then they're going to dismiss the no medical waiver card, correct?
That's correct.
Is that what you want to do, sir?
Yes.
And this was a commercial vehicle, correct?
Yes.
Okay, to that charge, failure to attach plates, sir, responsible or not responsible?
Responsible.
And to the charge of serious safety defect, file A, count 1, responsible or not responsible?
Responsible.
Uh,
No, wait, should I ask for cops?
I don't know, these are simple infractions. I might give you a cops on these.
All right.
All right, and then B file, the no medical waiver file is dismissed. Did he go into default on these?
No, I don't think so.
I don't think he was here February 26th. I'll set it aside. Why weren't you here February 26th?
Excuse me?
Why weren't you here on February 26th?
Should we move from one house to another?
All right, good enough. I'm accepting your plea to the serious safety defect. Fines costs on that, $325. I'll make it $300. I'll dismiss count 2, and on the failure to attach plate, $200. You can go down the hall, that's $500, pay it all, and we're done. Okay?
Thank you, Judge.
Thank you. Give me 1 second here. I walked into a blizzard here, it looks like. You have Ross?
Yes.
Ross.
Good morning, Your Honor. William Mays, on behalf of Mr. Jalen Ross. Mr. Ross.
I gotta call it though.
Oh.
Jalen Edward Ross, 260-646605 A and B. Your name, sir?
Jalen Edward Ross.
Mr. Mays?
Judge, we have gone through his rights explicitly. He signed and executed an advice of rights form. Prosecuting attorney has agreed to dismiss the original charge of OWI Supertrunk for an amended count of operating while visibly impaired, dismissing the PBT ticket, and also in the comments to that, which I need a copy of before I leave, they're withdrawing the implied consent refusal under Rule 257-305 sub 4, which is scheduled for next week.
Okay.
Mr. Ross understands the maximum possible penalties and is prepared to plead guilty at this time. Is that correct?
Yes, Your Honor.
All right. If you plead guilty to operating while impaired, I'm going to go ahead and dismiss the super drunk and the PBT refusal. I understand your lawyer and the prosecutor have worked this out with regard to the implied consent suspension. The impaired charge will call for, you did stand mute, wait for my reading, right?
Stand mute, wait for them reading.
If you plead the impaired now, operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service, court costs are all 4 points. License suspension or revocation in accordance with your record. Your vehicle could be, or might have to be immobilized depending upon your record. You understand that?
Yes, Your Honor.
And did you sign, read, and understand an advice or rights form here today?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and there will be no trial. Do you understand that?
I understand.
Any questions before we go on? To the charge operating while visibly impaired, how do you plead?
Plead guilty.
Were you operating a motor vehicle on West Jefferson near Sibley in the city of Trent at 2:26 in the morning on February the 7th of 26?
Yes, sir.
Prior to that, did you drink alcohol? And if so, what did you drink and how much did you drink?
I had about roughly 7 to 8 Bud Lights, and following that, 5 or 6 Jaeger bombs.
Why were you pulled over by the police?
It was aware to me that I had fallen asleep at a light with my foot on the brake pedal, and then they had woken me up and we pulled over to the side.
And you think you fell asleep, at least in part because of your alcohol consumption?
I believe it isn't drive still. My foot was on.
Yeah.
No, did you fall asleep because of the alcohol?
Into that and due to being awake for 25 hours, I was recently shifted to midnights, but that is.
Okay. And when you were, okay, so you were arrested, transported to the police station and administered an intoxilizer, is that?
No, blood test, 0.19.
Blood
Stipulation
test.
purposes.
I'm sorry. Okay, and you'll stipulate that was an accurate reading?
Yes.
Are you on probation or parole, Mr. Ross?
No.
Anybody in the world forced you to plead guilty?
No.
Plea is accepted to impaired driving. I'm dismissing the super drunk. I'm dismissing the PBT refusal. I'm going to order a screening and assessment. You'll go down the hall, you'll get your court date, which we're going to give you, and then you'll go back over to probation, fill out a questionnaire and be interviewed. I'm going to give you $1,000 personal bond. You don't have to post any money. Here are your bond conditions. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. I want you to attend a 12-step meeting twice a week in person. My court officer is going to get into a form. Every time you go, you have to have that form signed. Every time you come to court, you have to bring that form with you. Do you understand that, sir?
Yes, Your Honor.
All right. I'll give you the court date now. We'll see if this is good with you, Mr. Mays.
Sure.
What do you have for me, Heather?
Judge, we could do, how about April 23rd at 8:30?
Good that day?
23rd. I can't remember. Do I have Gardner here that morning? Is that here? I'm drawing a blank. I've got,
I think that's next week, isn't it? Or the week after?
April 23rd, or I'm sorry, which one is he looking for?
23rd is kind of full. I thought for some reason I may have a hearing here already. I've got a 9:15 in Romulus.
I can give you another date. It's not a big deal. What other day do I have with Trenton?
Well, we have April 7th in the afternoon. We're getting kind of full that day.
April 7th in the afternoon? That's my mother's birthday. I want to go to, I don't want to be working too hard that day. I'm gonna go
Yeah,
home.
we're kind
Take
of
out the
full that
lunch.
afternoon, Judge. That's why I'm trying to push everything to our next Trenton day, the 23rd.
Can you do the 23rd or not? If you can't, you
I
can't.
can do the afternoon.
We'll do it 1 o'clock.
Okay,
We'll do it April 23rd at 1 p.m. Okay?
thank you.
There was no, actually, Heather, we don't really, there's not gonna be any restitution here. Do you want to just give me a Monday or something?
I can do that, Judge.
Let's just do a Monday.
Or you want to do a Monday, or we could even do, on like one of our probation days too, a Tuesday.
Fine, either one.
How about, does April 14th work for you?
How's that?
Sure.
April 14th at 8:30.
Okay.
Okay? All right. Anything else, Mr. Mays?
No, thank you very much, Your Honor.
Have a good day. Good luck, sir. Thank you. And I'm just gonna defer, no, that's it. That's it. We're all set. Thank you.
Judge, can I grab that file from you, though? I need to
Yeah,
make a copy of that. for
Yeah.
the Secretary of State.
Heather, Mr. Mays is gonna bring the file down. can make a copy of that. Can you make a copy of that stip form, please?
Thanks so much.
Thank you.
Wonderful day.
You too. All right, who else do I have here? We got all these lawyers waiting around. What do you have, Mr. Graziani?
I've got Luke Durant, sir.
Mr. French, what do you have?
I have a ticket matter on Wood.
Let me call that Charlie Marianne Wood, 26G306904.
For the record, Your Honor, good to see you, albeit by Zoom.
Yeah, good to see you. I haven't seen you in a while. You doing all right?
Yeah, everything's fine. I appreciate the way you're moving through this docket as well. Ron French, for the record, appearing on behalf of Mrs. Wood.
All right, so this is a minor accident, no injuries. He's offering the impeding. You're authorized to enter that plea on behalf of your client, true?
I am, Your Honor.
To that charge of impeding traffic, responsible or not responsible?
Responsible.
Plea is accepted to impeding, original charge dismissed, 195, due by April the 9th, okay?
That's
Have
fine.
a good day.
Thank you.
Okay, I came in for vet, the prosecutor review.
I wanted actually to have, I don't want to dismiss it if she didn't do her community service. I want you to take this over to probation, John, please, and tell them I need to check on, they need to check on that.
The record indicates that she's compliant, but when I asked her about it, she said.
I know. And they didn't address it in their notes. They didn't say community service completed or not completed. So take it over to whoever the probation officer was. I'm sorry. I didn't know I called you in there on that. I didn't mean to.
Yeah.
Okay.
Thanks, Doug.
Thanks. Jalen, Dominic, Searcy, 260-647-832, A and B and C. Your name, sir.
Dominic Sears.
All right. Good morning. You're charged with drive while suspended. And you have 2 civil infractions, expired plate and no proof of insurance. You have the right to an attorney. If you want one, I will give you one. If you want a lawyer.
I'm not.
I'm gonna go ahead and arraign you then. I'll explain the charges. I'll send you to the prosecutor. On February the 18th and 26th, it is alleged that you did operate a motor vehicle on King near Douglas and Trenton at 3:10 p.m. That is a misdemeanor, punishable by up to 500 fines, 93 days jail. Costs are all those are 2 points. Do you understand that? And did you sign, read, and understand the advice of rights form? If you plead guilty at any time, you'll be giving up all those rights, and we're not gonna have a trial. Do you understand that? You also have 2 other charges, expired plate and no insurance. Those are civil infractions. Do you understand that? You still wish to waive your right to a lawyer? I'll enter a not guilty plea. I'll enter a plea of denials on these civil infractions. $500 personal bond. You don't have to post any money. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. You go out in the hall and he's going to set you up with the city attorney for Trenton. And you'll go talk to the city attorney. Either way, you're coming back in front of him, okay? All right, good luck. Harold, Lloyd, Reed, the 4th. Which one did you say you had again?
Oh, myself, Judge, I have Luke Durant, sir.
Come on up, Mr. Reed, 26G306837. Your name?
Harold Lloyd Reed, the 4th.
All right, you are charged with leaving the scene of a property damage accident. You have the right to a lawyer. Would you like a lawyer?
I'll take it.
On February 7 of 26, it is alleged that you did operate a motor vehicle and that you did leave the scene of that motor vehicle following an accident that occurred on Jefferson near South Gibraltar in Gibraltar at 1 o'clock in the morning. That is a misdemeanor and it's got rather severe consequences, up to 100 fines, 90 days jail, costs, or all those 6 points would be added to your traffic record. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights. And we're not going to have a trial or a hearing. Do you understand that?
Yes, sir.
You still wish to waive your right to a lawyer?
With the 6 points on my license, how many are you allowed to have in the city?
You're allowed to have 11 before they suspend you, but I haven't seen your record yet. I'd get a lawyer. I'll give you a lawyer. $100. You don't want a lawyer?
I just want to get it over with.
You don't want to be that quick about this one, okay?
I'll take a lawyer.
All right, not guilty, please entered. $500 personal bond. We'll give you a lawyer. This one goes to the JIB prosecutor, Gibraltar case. You cannot leave the state without the consent of the court to violate a law. You must appear in court as directed. Do you understand that?
Oh, Your Honor? I believe that, I know what I did, you know what I mean? I know that I don't mean like I'm not guilty. I just don't know,
What's that?
like, I don't know. Oh, yeah, I'll get an attorney. Does he want an attorney or the prosecutor? I
No.
don't know what the.
Hang on, slow down.
Yeah, I don't know.
Just slow down. Let me talk.
Yes, sir.
You don't need to fall on the sword here. Go let the lawyer help you, okay?
Who's the lawyer?
We're gonna set you up. Go out in the hallway. Nobody's trying to take up your time unnecessarily. We're just trying to be fair with you,
Yes, sir.
okay?
Thank you.
All right, and then the lawyer will go in and talk for you, all right?
Yes, sir.
All right, friends, let's move along for Lake County, Ohio. Judge O'Donnell has a fresh contestant.
He is basically asking the court to consider imposing the minimum sentence for the charge to which he pled guilty. He indicates that that he'd like to go on with the rest of his life, that he will abstain from alcoholic substances and driving without a license in the future. He realizes this has had an effect on him and those around him. He has been to prison before, but I think he would follow the court's orders and probation department's community control provisions if given the opportunity to do that. He knows he's looking at least 120 days in prison. He would like it not to be more than that. I explained that realistically the court may consider some additional time, but he would just like to get on with his life, put this matter behind him, and live each day as a new day without alcohol, Your Honor. Thank you.
Mr. Mackey, what do you want to tell me?
I didn't hear you, sir.
What do you want to tell me before I sentence you?
I want to tell you that first I want to apologize to my family and to the courts. Secondly, I just want to let you know that I promise to God it was just an honest mistake. I had just overcome drinking. I had just started back drinking. Well, I had drink after my dad died, but I didn't say I just started back drinking. That's when I came off maybe like a 6 year since I've been home from jail. That was like my first time drinking. But when I started drinking, it made me think more and more about my dad's death, so I really didn't like it. So we was out, and I'm not gonna sit here and just tell you no story. Like, I took some shots. One thing led to another. I thought I could make it home. I wasn't thinking. I did the dumbest decision in the world by getting behind that wheel. And I'm extremely sorry, apologetic for everything, and I'm willing to do any and everything it is to let you know that it was just a mistake. And I'm just trying to get back to my family, sir.
Where was the party?
It was on 185th.
And then you left the party to go home.
Yes, sir.
You were going in the wrong direction, weren't you?
Huh? No, I was going to my girl house. She stays on 305.
Okay. Well, you weren't going home.
That's where I was staying, sir.
You told me you were going home after the party.
Yeah, that's where I was staying with my girl on 305.
When's the last time you had a license?
My license was valid when it happened.
So what happened when you left 185th and you were going eastbound on Route 2. What happened?
It was a construction truck out there, and I actually pulled over to the side because I was behind the truck. And when I put this truck stopped and put his hazard lights on.
See the police car with the lights on?
No, the police car didn't have no lights on. So after the truck had his hazard lights on and it stopped, I had to back up to go around the truck. And as I was backing up to go around the truck, the officer pulled me over.
What kind of car were you driving?
A van, a Chrysler Town and Country.
Who's it titled to?
We not done paying for it, but it will be titled to me once I get finished.
Who's it titled to right now?
Eddie Auto Brokers.
Okay, so there's an officer right at the Warden Road spot on Route 2 in the right lane with his emergency lights on to keep the right lane closed from vehicular travel. That's after there were road signs as far back as the split indicating road work ahead. And another one that said right lane closed. The officer saw a Dodge, silver Dodge, pass the location of where the cop was in the left lane, continuously changed lanes without signaling to the right, struck a cone that was closing the far right lane down from vehicular use. Vehicle entered the closed lane and drove toward the construction vehicles with construction workers actively working in front of it. Vehicle nearly struck the rear of the construction truck and swerved out of the closed lane and continuously changed lanes without signaling, nearly striking another vehicle traveling on the roadway. So that's what happened. Right?
Yes, sir.
Well, that's not what you told me happened, but that's what happened. How many OVIs you got?
3.
4? 4?
4.
4? '09, Wycliffe. 10, Bratnall. 14, Euclid. 15, Euclid. So what happened in that last one?
Me and a buddy was in a car and we slid and I tried to turn the car and we almost hit a tree. And my dude, he sprained his wrist and he sued my insurance company and they came after me.
Okay,
so I got vehicular assault.
You got aggravated vehicular assault, right?
Yes.
And a DUI, right?
Yes.
And a drug possession, right?
Yes.
And a tampering with evidence. And you went to prison for that.
Yes.
Got out in March of 20. And now here we are in 25 with you being drunk as a skunk, going through a construction, closed lane in a construction site. Why? Why are you doing the same thing over and over again?
Your Honor, I'm not gonna even sit here and lie to you, man. It was an honest mistake, and
it's not a mistake.
I know the way that it seems. It may seem like it's a repeated offense.
It is a repeated offense, and it's not a mistake.
How
did you get to the party?
I drove there.
Okay. So did you did you drink them shots by mistake?
No, sir.
Okay, so it wasn't a mistake. It was a decision.
It was a dumb decision. As you
Right.
absolutely right, sir.
Right. And somebody with your experience, with 4 prior OVIs, 10 prior driving under suspensions, had no business doing what you were doing. It wasn't a mistake. So then, what's the date of this offense? 11/15 or 11/12?
11/13.
11/13, okay. On February 3rd, you pick up, you're driving again. Why were you driving in February?
Sure. I was driving to we was taking my stepson to a doctor's appointment, and my girl, she can see, she got like the astigmatism in her eye, and I was driving. And sir, honest to God, true, I didn't think that my license would be suspended until I was convicted.
Well, you were wrong.
Absolutely wrong.
Because it was suspended immediately. So you don't seem to pay too much attention to all this stuff.
I do, sir.
You don't. If you did, you wouldn't be sitting here for the 5th time. Now, despite all that, you don't seem to think you have a problem. Why is that?
I feel that like I can stop whenever I feel I can go cold turkey.
Then why didn't you?
I did, Your Honor, but
Well, you didn't because you drove through the construction zone and almost hit a couple people, so you didn't.
Well, like I say, I had a stint of a stop.
This stuff goes back. These OVIs go back to 09. 09, 10, 14, 15, 25, and you don't have a problem.
Yes, sir.
Okay. Well, you do have a problem. You don't, well, you don't have any insight. That's what you don't have. Because you got a big problem. If you didn't have a problem, you wouldn't be sitting here for the 5th time. You got a big problem.
Absolutely right.
What?
I said you're absolutely right, sir.
Okay. Why did you tell me you didn't have a problem? Why did you tell the probation officer who interviewed you that you didn't have a problem?
No, I told her, what I was meaning to her was telling her I did have a problem. Stop drinking. I didn't mean it like, that's like in trying to insult you. I would never try to insult you. I was telling her like, I don't have a problem with
What did he
stop
tell
drinking.
you?
Huh?
Your Honor, I asked him if he thought he presently had a problem with alcohol. He stated no. I asked him if he ever thought he had a problem with alcohol, and he stated no.
Okay. Anything else you want to tell me?
No, sir, what I meant by that is I don't have a problem with stopping.
Well, if you don't have a problem with stopping, then why didn't you stop?
That's an answer.
Huh?
That's an answer I can't answer.
Well, I mean, the correct answer is you have a problem and you can't stop.
Yes, sir.
That's the answer. Celeste?
Thank you, Your Honor. I couldn't disagree more with the defendant's characterization that this was an honest mistake. He has the 4 prior OVI convictions and served 3 prior prison terms. One of those was in connection with the prior felony OVI. And despite that repeated intervention, the defendant has continued to engage in the same exact behavior, which is drinking and driving. What makes this offense especially more troubling is that the defendant drove through a construction zone, almost striking the workers. The defendant does not appear to show any genuine remorse for that or fully understand or appreciate that he could seriously have injured or killed someone that day. And he should be acutely aware of that possibility since he had, in this prior case, pled to an aggravated vehicular assault in connection with the felony OVI. What's equally concerning is his refusal to acknowledge that he has a drinking problem. He also violated the conditions of bond in this case by continuing to drink and drive without a license. And whether or not the defendant knew that he had the BMV suspension, it was a condition of bond from this court for him not to drive. So without an acknowledgement that he has a problem, I think the likelihood of any meaningful rehabilitation is low. So this court is left with an offender who continues to endanger the public and shows no genuine remorse or insight into his behavior. The state is asking for 3 years prison, and there's the mandatory driver's license suspension and fine. Thank you.
All right, I've reviewed the pre-sentence report, the drug and alcohol evaluation, the letter in support of Mr. Mackey.
Yes.
And I've considered all the provisions in 29, 29, 11, 29, 29, 12, and 29, 29, 13. The pre-sentence report indicates a drug abuse conviction in 07, another one in 08, a felony drug possession in 08, a felony drug possession in 10, another one in 10, felony, another felony drug possession in 11, for which you were placed on probation. It was your 4th felony drug possession. You were put on probation. Actually, the 2nd and 3rd one, you went to prison. For about 5 months. 6 months. 4th one, you're put on probation in 11, which was about 8 months after you got out of prison. Violated probation 1, 2, 3, 4, 5 times, went to prison, and 15 for 2 months on that. Get out. May 31st of 15. Get this aggravated vehicular assault OVI felony. August of 17, go to prison for short of 3 years. 3 years, 36 months. And here we are again. As I said, 4 prior OVIs, 10 prior driving under suspension, 0 insight into the fact that you have a serious drug and alcohol problem because you keep getting convictions for drugs and getting convictions related to alcohol, yet you don't have a problem. If you don't have a problem, if that's true, then the only reason you're drinking is because you don't want to stop.
Yes,
Otherwise, you would stop, based on what you're telling me. So you need a lot of help that you refuse to get because you don't think you need it. That's the quandary you're in.
I do, sir.
Then you should get it. Okay, of course, you want it both ways. You don't have a problem. You can stop any time, but you do have a problem. So you are not amenable to community control. So I'm going to sentence you to 48 months in prison with credit for 88 days. And we'll impose a fine of $5,000. I'm going to suspend your driver's license for life. And when you get out of prison, you may be on post-release control for up to 2 years under the parole authority. They will place conditions on you. If you violate the conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which would be the greater of 12 months or the time left under post-release control, and the costs are assessed. Anything else, Ms. Alessi?
No, Your Honor. Thank you.
Mr. Mulkey?
No, Your Honor, thank you. 3 years and 9 months.
Well, friends, it's like we talked about on the pre-show this morning. Making the easy choices can lead to the toughest life. It's very easy for him to keep drinking, keep doing drugs, keep doing whatever he's doing, and now he's going to go to prison for 3 years. It's a harder choice to tell yourself that you have a problem and fix the problem, but it would lead to an easier life in the long run. That's the paradox that so many face, but here on TCF, the people that we see in front of judges, they're often taking that first route where they make the easy choices and it makes their lives more and more difficult. Just saying, little wisdom for you today. Let's go back to Judge Aquilina, new contestant there. Oh, no, pause. Before I forget, Nina, thank you for the $5 super chat during that last hearing. I also pointed out on the pre-show, we started this live show on TCF a little over a year ago. Today was actually the first anniversary of our first ever super chat for this show. So I'm going to take your $5 as a celebratory super chat, and I appreciate it. Anyways, let's get on with Judge Aquilina.
Divine Harris. Counsel, your appearance for the record.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Deshar Harris today, standing in for Mr. Austin, Attorney of Record.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Have you taken any medication yesterday or today? Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
My throat's sore. That's it.
Okay, but you're not feeling poorly enough where you don't understand me or your attorney, is that correct?
No.
So that's correct, yes?
Yes.
All right, counsel, you had an opportunity to speak with your client.
Yes, I did.
Do you believe he's oriented to date, time, and place, and does understand what's occurring?
I believe he does, Your Honor.
All right, thank you, sir. Have you had enough time with your attorney? If you need more time, it's fine with me. It's up to you. Let me tell you why we're here, and then you decide. So I have you on bond conditions for allegations that were made on or about November 28th, 2023. Count 1 is assault with intent to create bodily harm, less than murder or by strangulation, felony punishable by 10 years. Same count, count 2, so there's 2 counts of that. Count 4, domestic violence, a 93-day misdemeanor, unlawful imprisonment, a 15-year felony, interfering with crime report, a felony punishable by 10 years, and count 7, interfering with electronic communications, a 2-year felony, and another count of domestic violence, a 93-day misdemeanor. So there's 8 counts. You were placed on bond conditions, which included a teller. And I have a bench warrant here that says you should be held in contempt because your tether has been shut off due to non-payment. And the court signed that on February 21st, 2025. So a year ago? Is that how long we've been looking for him?
Over a year ago.
Okay, so that's the issue, sir. Do you need more time with your attorney?
Yes. There is a separate issue, Your Honor, and that is the new felony domestic violence case he picked up, which is how we have him now here.
Okay. Well, has it been bound over?
No, this occurred, let me see, on the 23rd, so it was 3 days ago. They found him at the scene. He was arrested. He's been charged with home invasion first degree, a couple counts of police officer, assault resisting obstructing, possession of controlled substance, and domestic violence with a new domestic violence victim. And so then he was picked up, where we were able to actually effectuate the original bench warrant. And now we have more cause because he's committed more crimes.
Okay, but that's still in district court.
Correct. Correct. I believe that, well, I've got it in front of me. The preliminary examination date is April 9th.
Okay. Would you like more time with your attorney? No? All right.
Is it gonna be about this or is it gonna be about the new?
The new one's not in front of me. You're innocent until proven guilty beyond a reasonable doubt, saying that these 8 charges in front of you. The issue here today is your tether being shut off due to non-payment. And that would be, I'm gonna amend this because I don't like when they don't put dates. And so they should give you notice of when. And so as best as I can tell, it'll be since on for about February 21st, 2025. Any objection to that amendment?
No, Your Honor.
No objection.
And so, counsel, are you waiving further arraignment?
I am here.
Will there be a plea or hearing?
You want to do Mr. Russell make an admission to this or have a hearing on the televisor? Judge, we wish to set this for a hearing.
All right, so we'll set this for a hearing. I'll just make a note that it was arraigned. We're pleading not guilty at this point. All your rights remain intact. The burden of proof here is by preponderance of the evidence, meaning more likely than not. You have a right to a hearing, you have a right to an attorney, which I understand you understand because your attorney is here with you. You have a right to cross-examine any witnesses and evidence brought against you. You have a right to choose to bring any witnesses you want in the court order those witnesses to be present. You can remain silent. Your silence cannot be used against you. You can also choose to testify. And should you testify, you will be subject to cross-examination. Do you understand your rights?
Yes.
All right. So we are going to set this, I'm going to set this for the same time as the bind over. When do you think that's going to be bound over, if it is?
The hearing's April, the examination's April 9th. Usually it takes a few weeks. I'd say May.
Great, May 6th at 11:30.
And there is one other matter, Your Honor.
And I'm going to put that that's with the new file.
Great.
What's the other matter?
So first, I want to make sure that it's clear on the record he's being remanded until that time in this file.
Yes, he's remanded.
And then secondly, I'm asking this court to revoke his phone privileges because discovered this morning he has already been talking to the victim on the new case, both directly and through his mother.
Sir, no contact means no contact. No contact directly through third parties, no smoke signal, carrier pigeon, sign language, The letters, Hallmark cards, don't get creative, because then I have to revoke your privileges and everybody's gonna have to come see you, except I suppose your attorney can Zoom with you or whatever they want to call it over there, but other than that, you have no contact through any means except somebody personally visiting you. I don't know the name of the new victim for those allegations. The allegations here and the file in front of me are Rosalind Tucker, Rozzlynn, Tucker, Tucker. There's no contact order. And then based on Public Act 53, there'd be a no contact order with any new alleged victims. So you understand, sir?
Yes.
Okay, so no phone or other communication privileges until we have further hearing and figure this out. Don't send any messages. If someone comes to visit you, don't write a note that you send to either victim, because contempt carries with it 93 days and or $7,500. The 93 days does not go against any time you're serving on these files. So, sir, don't tempt me.
So I'm not allowed to contact my mother or anybody like that?
Nope, nobody, not right now. When you start contacting victims, that's a problem.
I haven't contacted Rosalind at one time.
But there's a new allegation, and apparently you've been contacting.
Erica Ellsworth.
Okay, so that would be the new, could you spell it for the record?
Absolutely. Erica is E-R-I-C-A. And the last name Ellsworth is E-L-L-S-W-O-R-T-H.
So, sir, you can't contact. So we'll talk about who and when you can contact people and who you can contact, whether you're in front of me next. But meanwhile, here's the thing. You're just making a prosecutor whose hobby it is, like teasingly, to listen to these phone calls, to listen even more to your phone calls. And then he's gonna come here. We've had people with 1,400 phone calls to people they're not supposed to contact. You could get other charges for stalking, interfering in a case, all sorts of other charges, and the evidence is in the phone call. Don't make the prosecutor happy. Start doing the right things. I don't want to complicate this case, and I don't think you want to either. So right now, there's not going to be any contact. You have good counsel. I'm sure he'll make a motion for a contact or limited contact to limited people. I'm willing to consider that, but right now, let's keep it clean. You're remanded, no bond until further hearing. Thank you.
Thank you, Your Honor.
Did what time of the night? You say is it 9 or 1?
11:30 on the 6th.
That was the 6th.
May 6th, 11:30.
Thank you.
April 9th is the exam.
Okay, friends, let's head to the West Coast for a little while. This is Battleground, Washington. Judge Wheeler.
Please, for the record, have you state your name and date of birth for the record.
Kirk Osteck, 12/30/84.
Okay. Mr. Ostetek, it looks like what you're doing today is entering a guilty plea to a charge of driving while suspended in the 3rd degree. Is that your understanding?
Yes, my understanding.
Have you had plenty of time to talk to your attorney, Mr. Sowards, about the plea?
Yes, sir.
Need any additional time?
No, sir.
You are 41 years old, is that correct?
That's correct.
What's the highest grade in school you've completed, sir?
2 years of college.
Are you able to read and understand the English language?
Yep.
In entering a plea today to a charge of driving while suspended in the 3rd degree, you are giving up some important rights. You have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you, and witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty, and you have the right to appeal a finding of guilt after trial. Do you understand those rights, sir?
Yes, I do.
Understand that in pleading guilty today, you're waiving or giving up those rights.
Yes, I do.
The charges you are pleading to today is what is called a simple misdemeanor. It's subject to 90 days in jail and a $1,000 fine. There is a pretrial agreement that I'm holding up, sir. Do you understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law?
Yes, I understand.
Your Honor, could I interrupt for a quick moment?
Yes, Mr. Sowards?
The PTA was arranged last year. Mr. Busby has agreed to a simple 2-day credit time served sentence, not work crew.
Understood.
Thank you.
Understand let's see. So to the charge of driving while suspended third degree taking place on May 2nd, 2025 in the city of Richfield, Washington, how do you plead?
Guilty.
Are you entering the plea freely and voluntarily?
Yes, sir.
Has anyone made any threats or promises to get you to plead guilty?
No, sir.
Factual basis states on May 2nd, 2025 in Richfield, Washington, I drove a vehicle on a public road when my license to drive was suspended but capable of reinstatement. Is that a correct statement?
That's correct.
I'll accept the plea. I'll find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. Go ahead, Mr. Sowards.
Thank you, Your Honor. Mr. Osatek is unfortunately under bail for 2 charges, one from Vancouver, one from Clark County. The court does have in Battleground a $100 bail according to jail records. We'd ask that that be exonerated with his plea, and we'd ask that the court follow the credit time served recommended by the prosecution. And obviously under the Blazina, he is in custody, already been deemed indigent. He received counsel in both of his downtown cases based on his indigent status. So any discretionary fines, fees, or costs we would request be waived.
Mr. Osatek, anything you'd like to say, sir?
No, sir.
I will follow the recommendation of the parties. Count 1, 90 days jail with 88 days suspended, leaving 2 days to serve. Credit for 2 days served. It'll be a $1,000 fine with all 1,000 suspended. I will find pursuant the Blazina analysis that Mr. Osatek is indigent. Suspended sentence for 24 months. Conditions, no law violations, no driving without a valid license. I am not going to schedule a review or return date for Mr. Osatek. Mr. Osatek, any holds on this case with the plea today have now been lifted. It sounds like you may have some other matters that are still going to be keeping you in custody, but on this case, this matter is resolved. Do you have any questions, sir?
No, sir.
All right, that concludes your hearing. Thank you, sir. Thank you, Mr. Sowards.
Thank you.
All right, folks, good morning. If you're appearing in court today, you've been charged with either a misdemeanor or a gross misdemeanor in the cities of Battleground, Richfield, or La Center. When I call your name, I'm going to ask you to come up to the podium right in front of me. I'm going to ask you your name and your date of birth, and we're briefly going to discuss the charge that brings you in front of the court this morning. I'll also discuss your options today. One of the things I cannot do, though, is provide you legal advice. So if you're unsure how you want to proceed, you need some additional time to consider your options, feel free to let me know. You can have a seat, have some additional time to think things through. As you have seen already, I do have folks that are joining us from the Clark County Jail. I have a more limited time with the folks in custody. Because of that, I oftentimes have to take those matters out of order. My intention in doing so is not to keep anyone here any longer than they have to be. Very simply, I just have less time with the folks in custody. So I have Renee Martin in the courtroom. Come on up here. And sir, if I could have you state your name and date of birth, please, for the record.
My name is Renee Martin, February 4th, 1956.
Mr. Martin, you're making a first appearance, Raymond, on a charge of hit and run attended vehicle. Hit and run attended is a gross misdemeanor, sir. It's subject to 364 days in jail and a $5,000 fine. It's also a charge if you are convicted of it that carries a mandatory 90-day license suspension. I did review the associated police reports with the case. I did find what is called probable cause. I did read your financial declaration here. It does not look like you qualify for court-appointed counsel. So certainly one of the things we can do 2 different things today. The first is we can enter a not guilty plea and you can have time to hire an attorney. The second thing I can do is enter a not guilty plea and set up a time for you to talk to the city attorney. Which would you prefer to do?
What do you mean by talk to the city attorney?
We would schedule a court date forward. You would get contact information to speak to the city attorney to discuss your case if you'd like to find out what their recommendations would be.
I want to plead not guilty. This never occurred. I don't even know.
Again, hold on. We're not doing the trial today.
Okay.
I've talked to you only about 2 options. Explain them both and I'll explain them again. Your first option is to enter a not guilty plea and hire an attorney. Your second option is to plead not guilty and talk to the city attorney. They're your choice. Of those two options, which would you like to do today?
When you say talk to the, well, I don't understand what that means. I mean, am I giving up my right to hire an attorney in this case?
Why don't we enter a not guilty plea and you can hire an attorney?
I'm not guilty plea, hire an attorney.
Sounds great. So, sir, we're going to set 2 future court dates. You need to provide both of these dates to the attorney you choose to hire. First is what is called an attorney pretrial date. That is going to be on the 8th of April, 2026. It is not a required court date for you. It's a date for your attorney. Your next mandatory court date, sir, is going to be on the 30th of April, 2026 at 1:30 in the afternoon. You can be in person that day or on Zoom, but you do need to be present. Your release conditions are to violate no laws, appear at all mandatory court dates, to notify the court of any change of address or phone number. We're going to be providing you some documents at that very far desk over there by the door, sir. And once you have your paperwork, you are free to go. Thank you.
All right, I'll keep an eye on Battleground, see what's going on there, and if there's something to come back for, we will. But let's go and check back in with Judge DiSanto in Michigan.
You didn't. All right, and counsel? Good morning, Your Honor. John Goldpaw, P 30758, on behalf of Ms. Andrews. Ms. Andrews, would you please put your name on the record?
That's not coming through. Is that better? Yeah. All right, thank you. And good morning, and today is the date scheduled for the arraignment on this matter. And counsel?
As to the arraignment, Your Honor, she would stand mute for the charges, waive a form of all those charges, ask the plea of not guilty.
The court will waive the formal reading. Ma'am, you have the right to have an attorney. If you are unable to afford an attorney, you may have one appointed to represent you. And you did in fact have an opportunity to steal or to speak to an attorney today, correct? Yes, ma'am. Yes, ma'am. And the court has also signed the petition in order for appointed attorney for felony matters as well. And you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. And you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights? Yes. The court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on April 2nd. 10:15 a.m. And counsel asked to bond.
Thank you, Your Honor. As to bond, Ms. Andrews, right? Not Andrews, I'm sorry, Ms. Andrews is 43 years old. She's gainfully employed. She works at Five Guys Hamburger. She's been, right? The manager, excuse me. She's married, she's been married for 6 years. Her husband is with her today. She's not on probation. She's not on parole. There are no immigration issues. Your Honor, she indicated to me, though she's had some prior contacts, she has never missed any court appearances required to be at. I would note that this matter, the warrant, or the complaint rather, was issued on the 26th, I believe, of February. This incident occurred or allegedly occurred in February of 25. She was notified to be here. She's showed up, so she's not a flight risk. We're asking for a personal bond in this matter, sir.
Okay, and so ma'am, are you out on bond in any other jurisdiction? No, ma'am. Are you currently on probation or parole anywhere?
No, ma'am.
What's going on in your matter from Farmington Hills from 2024? The assault case, was that something that was going forward or no?
No, that was dismissed.
Okay. What's that?
No, I was just,
Asking about my books. No.
he's very nervous. It's kind of calming down. But it doesn't seem to be working.
Do you know Ms. Bassett?
No.
Weren't you in the home for purposes of home care?
Miss Bessie? I don't know, that wasn't her last name.
Bassett. You know, Mr. Robinson?
Not that you recall.
And where do you reside, ma'am?
23011 Colgate Street, I'm the senior position. Okay,
Sorry, there's a lot of pages to go through. I'm just trying to find addresses here. I have some serious concerns for the safety of the community with your client, counsel, given the nature of these allegations and her criminal history, which is similar to these charges. You're not doing home care for anybody?
No, ma'am. I work at I'm manager at Five Guys. I work literally every day. I think my next off day actually is. But I literally work every day. I close all this week. So I'm at work all this week from 2 to 11:30. I get off, I literally go home. My husband is right there until
Given the nature of the charges, reviewing Ms. Andrews' criminal history, and the amount of money involved in this situation here, the court has serious concerns for the safety of the public. The court will note that it does believe a high personal bond and significant conditions will protect the community. The court's going to order $50,000 personal bond with the following bond conditions. You are not to have any contact with Ms. Bassett, which you're claiming you don't know who she is, yet it's indicated you're part of her care team and the owner of all the purses and whatnot. Also, Mr. Robinson and Miss Arnoldi, who apparently are members of Ms. Bassett's family, nor are you allowed to have contact with Ms. Francis, who apparently is the owner or the supervisor of their home care company you worked for. You're not to return to 3200 Biddle Avenue, nor the residence or employment of any of the prosecution witnesses.
yes, ma'am.
You are not to possess or have access to any firearms or weapons. Do you have any of those?
No, ma'am.
Just have a seat. You'll get a copy of your bond conditions, and we'll see you back on April 2nd.
Thank you very much, Your Honor.
Thank you. Have a good day.
Okay, friends, I'm going to take us back to Judge Aquilina. I actually had a hearing queued up for her. However, I'm moving us just a little bit forward to another hearing. Just keep an eye, because somebody's going to zoom in and I have no idea what this hearing's about that we're going to watch, but just keep an eye on who and what kind of zooms in partway through this. No idea the context, but the visual will capture your attention. Judge Aquilina.
Yeah. This is docket 254217 FH, People of the State of Michigan versus Arrearage. Counsel, your appearance for the record.
Good morning, Your Honor. A.T. Bart Buxton on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Ali, standing in for Mr. Sarks today.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
You're supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had enough time to speak with your attorney?
Yes.
Thank you. I need you to, when you just shake your head, there's nothing in the record, so.
Oh, yes, ma'am.
This record's for you, it isn't for me. So if you want to remain silent, that's okay, but your record's gonna be junk. So we gotta make a good record, you and me, okay?
Yes, ma'am.
All right, very good. So, sir, you took a plea and you pled to controlled substance, possession of a controlled substance known as cocaine and or fentanyl. And that was done several weeks ago. So now you were supposed to be sentenced March 11th, and we could not do that because you did not appear to complete your pre-sentence investigation. We got a problem. So that is why you've been brought before this court. It says defendant failed to report to probation and complete his pre-sentence information report, PSI interview. And that is why you were brought before this court. Additionally, I don't have that you failed to appear.
He did fail to appear at the sentencing on March 11th.
So I'm going to amend this to say and fail to appear. Sentencing, March 11, 2026 at
9:30.
Yep, 9:30, thank you. Do you understand the allegations against you?
Yes, ma'am.
Are you waiving further arraignment?
Yes, Your Honor.
Will this be a plea or a hearing?
Plea, Your Honor.
Is that correct, sir? Are you pleading to the violations of failure to report for your pre-sentence investigation report, interview, as well as failure to report to the sentencing?
Yes, ma'am.
All right. And are you pleading to these of your own free will?
Yes, ma'am.
Anyone force, threaten, or coerce you?
No, I just had some issues outside, before my birthday, before my 41st birthday, a lash jumped on and I sort of missed it. And it wasn't nothing personally, so my apologies.
When's your birthday, sir?
March 8th.
Okay, so were you in the hospital?
I wanted to go to the hospital to make a report, but dealing with that, I would have been a snitch. I would have had to deal with more street violence, so
Okay.
no now.
While I understand, and that may have been good cause for you to not show up at the hearing, what you should have done is called your attorney, called my office, and just said, I'm sick, I can't show up. Got that? But here's the thing, if you would have shown up, I would have had to put you in lockup because you did not complete your pre-sentence investigation report, which you were supposed to do. You had 24 hours to contact probation and make and keep an appointment. We were very clear about that. If you don't remember it, we have a record of that. Do you remember you and I talking about that?
Yes, ma'am. Yes,
Well, what happened there? Did someone jump you the whole month of February and March?
No, ma'am, just in March.
Okay, so why couldn't you go to probation February at any time?
I thought it got like moved. I thought it got dismissed or moved down like to a different day.
What got dismissed? It
Back in
didn't.
February.
Sir, you pled. You had to go to probation and meet with them so they could do a report so I can get to sentencing. Do you understand that?
Yes.
What was difficult about understanding that and getting to probation?
I just missed it, Your Honor. I just missed it.
Okay, so here's the consequence of that. Well, first of all, so I'll just get rid of the bench warrant as to failure to appear for the hearing. Neither for sentencing, that neither here nor there. If you would have shown up, we're at the same place. So how do you plead to failure to report for your pre-sentence interview? How do you plead? Guilty, not guilty? Sir, did you show up or not?
No, I did not show up.
Okay, so you're pleading guilty or not guilty?
I guess I'm guilty.
I don't want you to guess. You failed to show up. Doesn't that equal guilty of violating my order to show up?
Yes, ma'am.
Okay, well, you are guilty of that. By your own admission, no matter what you call it or how you dance around it. So I'm finding that you're in contempt of court, and here's what we're going to do. And that's by preponderance of the evidence, your own admission, and the evidence on the record where you didn't show up, we had to bench warrant you, and now we had to pick you up. I need a. Where are you living, sir?
Well, I went down to Detroit to see my probation officer. Then I came back here.
Okay, so where are you living? I have you at Appleton. Are you still living there?
No, ma'am. That address was changed.
Okay, well, let me see what I have here.
I should have the Longview address.
Can you tell me what address we have? I don't know if I have it on the. What address do we have on the file? I had Barnes Avenue at one point, and then I had Appleton, and now we're checking the computer to see what.
No, ma'am. I had Barnes down.
And you may have, I just don't,
Appleton, that was like years ago.
okay, well, let me just see what we have in the computer.
Longview Street.
Okay, we still have 1139 Longview?
Correct.
Okay, 11039 Longview. Okay, what's your correct address, sir?
11039 Longview Street, Detroit, Michigan, 48213.
Isn't that what we just said? The 11039 Longview Street? Is that the
What she
correct
said,
one?
Appleton, yes, ma'am.
Okay, so the Longview is the correct one.
Yes, ma'am.
Who lives there with you?
Myself.
And are you on probation in Detroit too?
Yes, ma'am.
Okay. Are you working?
Yes, ma'am.
What do you do?
Lawn care, snow removal, home improvement. Mr. Sir, should we give you paperwork? Even if we have an emergency, we need hospital paper, we don't have it. But I didn't call because my phone was smashed. You are like, you're not the defensive attorney, can I represent? Shit.
All right, so I'm gonna give you a $25,000 PR bond after the PSIR interview is completed.
Ms. Aquilina,
What?
did y'all happen to last get another case, or is this for a different court?
This is for this court only.
Was this the one for
This is the one for possession of cocaine and or fentanyl.
and that one, the one from last year, right?
It's the one from 2025, last year. It occurred on April 10th, 2023. You got other ones floating around I need to know about?
No, man, I'm just trying to figure out which case this is for. I just heard two different cases.
Nope.
Okay.
Nope, this is the only one, but you do have one in Detroit that you're on probation for, right?
For gun and yes,
Yeah.
ma'am. Yes,
So
ma'am.
that, you got that file and you got this file. Is there some other file I should be knowing about?
No, ma'am.
So, Your Honor, there is a case that Mr. Ali has from November 24th of 2025 that is in the district court right now.
So did you fail to appear for that? Is there another bench warrant out there?
No, because the PCC on that is set for next Tuesday, Your Honor.
Okay, perfect. Well, sir, I'm gonna have you appear in front of me May 20th at 11 a.m. on all files. You will not have any contact with any victim. You will continue to report your pretrial services as directed. And all of the other bond conditions that are in place will be in place. You can appear in Zoom or here. If you can't get to Detroit, we're gonna give you my Zoom number.
Yes, ma'am. And may I please get my paperwork this time?
What paper?
Son, I gotta come back to court and everything.
Yeah, we should have given it to you last time, but we're gonna give it to you this time.
Thank you.
You know all your other bond conditions, or you need me to fill it out again?
Yes, ma'am.
You know all your bond conditions? Not to violate the law, show up, no alcohol, no drugs, no assaultive behavior, no contact with victims, witnesses,
Yes,
all of
ma'am.
that. Those are all still in place. I'm just amending this so that you get a PR bond after probation comes to see you.
Yes, ma'am.
Sir, I start to get really upset when grow food is put on your files and they start springing up and multiplying. You understand what I'm saying?
Yes, ma'am.
I don't want any fertilizer on these files. I don't want any more criminal behavior. I don't want any more missed appointments with me, probation, pretrial services. Start behaving, because otherwise you're gonna get real comfortable in that jumpsuit. I'll multiply the jumpsuits. Got that?
Yes, ma'am. That won't happen.
I deal in evidence, sir, and that's what I want to see.
Okay.
Great.
Thank you, Ms. Aquilina.
Make sure you get copies. Here's the. How many jail days do you have? Well, the jail days, they're going to continue until he is interviewed by probation, so he'll get the jail days as credited by the jail. Because he's not getting out right now, but as of today, when did you get picked up on this?
On the 20th, 19th, between the 19th and the 20th.
Okay, so the 19th of March,
Yes, ma'am.
so you get 8 days credit for 8 days plus any days you spend awaiting probation. Thank you.
We'll talk to the probation, see if we can get the interview expedited as quickly as possible. Can't control that, but.
And Your Honor.
They may or may not care, I don't know.
What is that sentence, or what is the time on 5/20?
11.
11 o'clock.
11.
Thank you.
Make sure it's my Zoom number on that paper. It should be on the paper we do it. You can just give him one of my cards. Here. Staple it right there.
I can't say it.
Or whatever.
I can't say it.
Here, do you have one? Got the Zoom number right on there. Fine.
So I hope you all enjoyed getting a glimpse at Mr. Jeff Observer. Clearly had just zoomed in to watch the court. So a little behind the scenes here, since this is kind of what I do. There are courts in the United States that will allow you to zoom in and observe. I use them. But the general rule is, number one, you don't turn on your camera. Number two, you keep your mouth shut. In other words, fade into the background and let the court do its business. Mr. Observer clearly didn't get the memo, I guess. Looks like Aquilina is going to call up another person. Let's just ride here.
Are these new interns, law students?
Very nice.
Welcome.
Hello.
Thank you.
Good color in you.
Thank you very much. And we have a plea agreement, and may I approach, and I have also a advice of rights too as well.
Yes, you may. Thank you. This is document 25-1538 People of the State of Michigan versus Anthony Matthew. Counsel, your appearances.
Good afternoon, Your Honor. Andrea McCray appearing on behalf of the people.
Good afternoon, Your Honor. Christina Lake appearing on behalf of Anthony Matthew. He is standing to the right of me.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Put your hand down. Sir, you taken any medication yesterday or today?
Yes.
And is it anything that would interfere in your ability to understand your attorney or the court?
No.
Is there medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
Have you had enough time to speak with your attorney?
Yes.
Thank you. Sir, are you a U.S. citizen?
Yes.
And counsel is going to be a plea today, is that correct?
That is correct, Your Honor.
And sir, did whatever you're pleading to, which I will hear in just a moment, were you on probation, parole, or bond conditions before this judge or another?
No.
Are you employed?
I was.
What did you do?
I was a flight attendant.
Flight attendant?
Yes, ma'am.
Did you graduate high school?
Yes.
And is there a plea agreement?
Yes, Your Honor, the defendant has agreed to plead guilty to count one, child sexually abusive activity. In exchange for his plea on count one, the people agree to dismiss counts 2, 3, and 4. There is a sentence agreement of a fixed minimum of 35 months in the Michigan Department of Corrections, MPOC. The defendant also agrees to forfeit all devices seized as part of this case.
Counsel, is that full, fair, accurate, and complete?
Yes.
Sir, is that full, fair, accurate, and complete?
Yes.
And counsel, you're waiving reading counts 2, 3, and 4?
We are.
Thank you. As to count one.
Thank you, Your Honor. This is the people of the state of Michigan versus Anthony Puska Matthew in circuit case 25-1538-FH, state of Michigan, county of Hingham. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant did in count one, child sexually abusive activity on or about January 28, 2025 at 2401 Showtime, SHOWTIME Drive, Lansing, Michigan, 48912 in Hingham County, Michigan. The defendant did attempt to prepare or conspire to arrange for, produce, make, copy, reproduce, or finance any child sexually abusive activity contrary to MCL 750.145C2. This is a felony that carries a maximum period of incarceration up to 20 years in prison and or a $100,000 fine. Just 1 second, Your Honor, because the information doesn't have the SORA notice on it, which is weird, because this would be a SORA.
I saw that and I wondered if that's why you made the deal to count one, because it didn't have the SORA.
Oh, no, it should. It should. So this is a tier 2 offense under the Sex Offender Registration Act. SORA is a tier 3 offense if the defendant has a previous conviction, a prior conviction for a tier 2 offense, MCL 28.722 T and U. And this offense was committed against the peace and dignity of the people of the state of Michigan. Sister Counsel, are you waiving that the SORA notice is not on count one, or do you need to go upstairs and get a new one?
No, I don't need you to get a new one, but I just want to make sure. Yeah, I can go to the prosecutor table for a quick second here. Just wanted to make sure that. No, we didn't need the prosecutor to go up there.
And he understands and acknowledges that this is a SORA offense and he will have to register, correct?
He does, and I'll ask him that too during the factual basis too as well.
Understood, great. Thank you, Your Honor.
Thank you. Sir, did you understand what was just read?
Yes.
So you understand count one, child sexually abusive activity is a felony punishable by 20 years and or $100,000. It also carries with it a SORA notice, meaning that you will have to comply with the Sex Offender Registration Notification Act. Do you understand that?
Yes.
All right. And counsel, would you agree with me that this is a tier 2, not a tier 3? He doesn't have a prior, is that correct?
That's correct.
Okay. Do you understand what that means, sir?
Yes.
Okay, thank you. And although it was not on the felony information properly, it was also noticed to you on count 2. It also carried that same SORA notice. Would you agree with that?
Yes.
And it also was listed on counts 3 and 4. So it's missing on count 1, but when you were arraigned, you heard it at least 3 times.
Yes.
I also explained it to him a couple times, Your Honor.
Appreciate that. I figured you would, but just so we make that record for appeal purposes, if there is any question.
Correct.
All right. So, sir, you've had enough time to spend with your attorney talking about the plea, the SORA notice, and all of that.
Yes.
All right. And you wish to proceed with the plea.
Yes.
All right. Very good. And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, ma'am.
Did you understand what you read?
Yes.
And if you had any questions, was your attorney able to answer those?
Yes.
And did anyone force, threaten, or coerce you to plead?
No.
Anyone promise you anything other than the plea agreement that's causing you to plead? And you've chosen to plead after you talked with your attorney and reviewed everything?
Yes.
And you're pleading of your own free will?
Yes.
And you've been satisfied with the representation of your attorney?
Yes.
As to count one, child sexually abusive activity, how do you plead?
I'm guilty.
And do you understand that by pleading, you're also giving up your automatic right of appeal? If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal, and they may or may not take up your issues. It just depends on how important they think it is. Had you had a bench trial or a jury trial and you were unhappy with anything, they have to take a look at your unhappiness, but now it's their choice. Do you understand that?
Yes.
Do you also understand that by pleading, you're giving up certain rights and defenses you would have had you gone to jury trial, such as holding the people to their burden of proving beyond a reasonable doubt, cross-examining witnesses and evidence, choosing to bring witnesses and put forth evidence, choosing whether or not you wanted to remain silent, your silence could not be used against you, or testifying. If you testified, you'd be subject to cross-examination. You understand you're giving up all those rights?
Yes.
All right. And other than the plea agreement, has anyone told you what I will do at sentencing? Has anyone told you anything that I will do at sentencing other than the plea agreement? The plea agreement contains that you will be sentenced in 35 months to up to the 20 years. And the devices are going to all be seized. But is there anything else that you've been promised as to what I will do at sentencing?
No.
That's the right answer. I know it sounds like a trick question, but it's not. And the reason is, sir, I'm not fully informed. When I'm fully informed, then I'll make up my mind about sentencing. Do you understand that?
Yes.
Now, this plea agreement will remain in effect as long as you do everything correctly. If between now and sentencing you violate the law or bond conditions, then I do not have to honor it, and I do not have to honor withdrawing your plea. But if I violate it, I would have to allow you to withdraw your plea. Does that make sense to you as well?
Yes.
All right. Sir, did this offense occur on or about January 28th, 2025?
Yes.
In the Township of Lansing County of Hingham, State of Michigan?
Yes.
At a specific location known as 2401 Showtime Drive?
Yes.
Did you attempt to or conspire with someone to arrange for, produce, or make copies of child sexual abusive material?
Yes.
What did you specifically do? Counsel, I'm sorry.
It's actually activity, it's not material, Your Honor.
Okay.
Yes, so that's an important distinction. I don't know.
Okay, and I don't get police
I
reports,
know.
so how about, it's like you carry on and question.
All right, thank you so much. We got the first half of it done here. Did you get on a social media site?
Yes.
Okay, and what was that social media site?
Grindr.
What was it?
Grindr.
Okay, and how old, or excuse me, did you meet a person on Grindr?
Yes.
Okay, and can you tell the court how old that person you believed was?
50.
How old?
15.
Okay, and when the person told you he was 15, did you ask him to perform sexual acts?
Yes.
Okay, and did you offer this person money to meet you at the hotel?
Yes.
And how did you offer him money?
Through an Uber ride.
Through Uber ride?
Yeah.
Okay. And you know that at the time that this happened, that this is illegal to do this, correct?
Correct. Yes.
All right, I have no further questions.
I'm gonna have people any additional questions?
The point of you going to this location, sir, was to have some type of sexual interaction, I believe it was fellatio, right, with this person that you believe to be under 18, correct?
I don't think that's not a good question, because the point wasn't that he was there. He was actually at the hotel waiting for his airline ticket, or excuse me, his airplane, his next thing. So his point is he was waiting to, I mean, I believe that our questions meet the statutory basis of it.
I just want to make sure that I hear you that you didn't like my question, but I want to make sure that we meet it all so we don't have an issue later. So, sir, you were at this hotel, correct?
Yes.
Okay, and you were talking with someone that you believe to be 15 years old, correct?
Yes.
Okay, and you asked him to come meet you at your hotel, correct?
Yes.
Okay, and that was to had performed fellatio either on him or him perform fellatio on you, correct?
Yes,
Okay, and we're gonna pay for his Uber, correct?
correct.
Okay, and
you believed he was a minor?
Did you believe at the time period that he was a minor?
Yes,
And you still allowed him to, and you still asked him to do this act with you,
yes,
the fellatio, correct?
yes.
All
And
right.
how old are you, sir?
36 now.
I don't have any other questions.
Thank you. Ms. Light, did you have any additional questions?
Just one follow-up, Your Honor. We talked about the SORA notice. Your attorney did explain, I did explain that to you, correct, about the SORA notice and registration and things of that nature, correct?
Yes,
All right. So you understand that just because it does not have this on, the notice on here, that you understood that it was on the SORA notice, correct?
yes.
All right. I have no further questions.
Thank you. Our counsel, where promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No, Your Honor.
Does the court comply with court rule?
Yes.
Yes, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count one will enter with the SORA notice, and the court does note that defendant has, despite it not being correct, we have corrected on the record, and you talked about it with his attorney, as well as the three other counts that are now being dismissed had that notice as appropriate, which would be identical to count one. And it was read today on the record. He had ample time to dispute this, ask for amended information, send it back to district court, or do anything else, and everybody's waived it to move this forward. So the court does find that count one should be entered with that amendment, and the people will file amended information. Count two, count three, and count four are dismissed in their entirety, along with any outstanding warrants. If any related to this file, those will be recalled and dismissed. Do we have a sentencing date?
June 10th at 9:30.
Does that meet with your schedule, Ms. Lang?
I'm just checking it real quick here.
And Judge, I'll file an amended information today with that SORA notice.
Thank you. Did you say 10:30 or 9:30?
9:30.
And that was June 10th, correct?
June 10th at 9:30.
That'll work fine, Your Honor.
Okay, sir, you'll need to cooperate with probation. They're going to come and see you. They're going to do a very detailed pre-sentence investigation report that we'll talk about at the time of sentencing, and Ms. Light will come see you, and you two will review it as well to make sure it's correct, okay? Bond is revoked, so all your time counts. Is there anything else?
Most likely, Your Honor, we'll have a sentencing memorandum, but there's a couple things that I'll attach that I don't want in the public file, so.
If you attach it to me, it will not get in the public file.
I know.
So
I just wanted to make sure that that was clear in the record, so that I will give the prosecutor a copy to you as well.
okay, so just follow whatever's public, and then just write to us not to be filed. So if somebody doesn't make that mistake, and the prosecutor and I will make sure we adhere to that.
Absolutely. Thank you, Your Honor.
All right.
Have a wonderful day. Great seeing you.
Nice seeing you.
Okay, friends, TCF Live, about another half an hour to go. Actually, before we go anyplace else, reminder, tonight, Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. You will want to be there because it's the last Thursday of the month, which means the chat controls what we discuss. So be there, bring your questions, and we will discuss them again, 8 p.m. Eastern, 5 p.m. Pacific, right here at TCF. Okie dokie. Back to Judge Mom.
Your Honor, John Goldflaw, P 30758, on behalf of Ms. Hamlin. Ms. Hamlin, please put your name on the record.
Linda Hamlin. All right, very good. Good morning. Thank you. And today is the date scheduled for the show cause. Ms. Hamlin was discharged from probation and she owes a balance of $950.
That is correct, Your Honor.
She's forgotten about that or missed some payments?
She hadn't forgotten about it, Your Honor. She did fall on some hard times. She did lose her job. She's now back working. Is that correct?
Yeah, I normally work 2 jobs and I want my other one closed. And so I'm just down to the one.
She does have a Well, she does have $500 to pay today, and she would appreciate a payment plan.
Okay, and so ma'am, did you contact into the court at all when you had lost the one job?
No.
Okay, so that would have been helpful and prevented you from having to come in today, but I'm glad that you are here today and you're able to make a payment on this balance, and it's still $950 from from what it shows here. So I will indicate that you're paying $500 today. And then as to the balance of $450, ma'am, what payment plan would you like?
It could be the same as before. I think it was 50.
Okay. So $50 per month, and since you're paying $500 today, would you like to begin that April 24th? That's 4 weeks from tomorrow.
Yes.
All right. Okay, and then as long as you're continuing with those payments, you won't have to come back.
Okay, thank you.
All right, thank you. You can even get information about paying online at the window too. So
Okay.
just stop at the window and make your payment.
Thank you.
Thank you. Good luck to you.
Thank you, Your Honor.
All right, this is the matter of Froylan Hernandez, 232025.
Your Honor.
Good morning.
Mr. John Goldpaw, P. 30758 on behalf of Mr. Hernandez. Your Honor, Mr. Hernandez indicates to me that he was here approximately a month ago, and that at that point in time, the court placed him on a payment plan in the amount of $50 per month. He paid $50. He's paid the first $50. He owes quite a substantial amount, and he has another $50, which he's going to be able to pay tomorrow, and wishing to continue in his payment plan.
Okay, and so, sir, your name for the record, please.
Froylan Hernandez.
Okay, thank you. Okay, so I do show, yes, your client was here on February 5th. And so he was supposed to pay $50 per month beginning February 6th. He was also going to pay $300 from his income tax refund. And then set it for today, or set it for a date if he misses the payment. So did you miss a payment?
No,
Did you pay the $300?
I haven't got the income tax yet.
Okay, when do you expect, when did you already file your refund, sir?
Yes.
Okay, when did you do that?
So, and it was February 15th, something like that.
Okay. All right. Did you make your payment in March? Did you make your payment March 6th?
No.
No, that's why you're back on the docket today.
Okay.
He has.
I didn't know there was like a specific date.
Yes, sir. $50 per month beginning February 6th. That means the 6th of every month you make your payment.
And I indicate, Your Honor, yes, $50. He will be paying that tomorrow. Is that correct?
Yes.
Okay, well, just so you know, the 6th of April is right behind it. Are you paying another $50 on April 6th?
Yes.
You're sure? And when, it doesn't indicate when you're expected to receive your refund?
No, it says.
Okay.
As soon as I get it, I'll pay.
All right. April 6th is a Monday, sir. So that's literally 10 days after you make your payment tomorrow.
Okay.
Don't miss it.
Okay.
Okay.
Thank
You
you.
can stop at the window to get information about paying it online as well, sir, so you don't have to come on in.
Thank you, Your Honor.
You're welcome. Have a good day. And we are on the record of the matter of the state of Michigan versus John Stone, 211942. There should be another file for Mr. Stone. No? No. Okay,
Not that I see.
you have another sentencing date. It got moved. Oh, we probably,
First, I think.
that's next Wednesday. Yes, okay. All right, so I do apologize, sir. But since this was a state of Michigan case originally, that's why it was on for today. So had we caught that, we would have been able to put them on the same day potentially. But in any event, you have a counsel your appearance, please.
Your Honor, John Goldwasser, P 30758 Alpha. Stone, please put your name on the record.
John Stone.
Okay, so today's the date scheduled for the show cause hearing. You have a balance of like $1,885, have not made a payment since you were sentenced on October 14th of 2022.
Correct.
Your Honor, Mr. Thorne's fell on quite a few hard times since that date. I understand he's had some problems. In fact, I represented him in this matter. Correct. And as you've indicated, he has another matter pending for sentencing on April 1st. He indicated to me that he is continuing to turn his life around. He's doing the best he can. He does have $50 to pay today and wishes to enter a payment plan for $100 per month. He paid $50 today, excuse me. And he would ask to enter into a payment plan of $100 per month. Starting on today's the 26th of each month.
Okay, and I'm aware that Mr. Stone has fallen on some hard times. My question is though, sir, so now you're able to enter into a payment plan. What's happened the last 3.5 years that you couldn't do that?
I happened, alcohol happened, so. And it's just one thing after another, and I did all this for myself. But, you know, I thought this was only fines and costs, which nevertheless I shouldn't have neglected, but I forgot there was restitution to this. A family paid $1,000 deductible. So I'm gonna, like $100 a month is the bare minimum. I just started working again in landscaping, so we're busy already and we'll be paying them out all summer. So $100 a month is the minimum. I want to address this for sure as fast as I can.
All right. Well, I do appreciate that you acknowledge that, you know, somebody's out of pocket money from that. So $100 per month beginning today, you indicated?
I paid $50 today, and by this date of next month, $100 a month.
All right. So beginning April 26th, $100 per month. Defendant paid $50 today.
Okay, you see.
Which means that you won't have to come back into court unless you miss a payment.
And Your Honor, he did pay the 50 today already.
Right, I just made a note.
Yeah, I just wanted to make sure. He's looking at me.
Yes.
Yes, you got it.
All right. Very good. Thank you. Have a good day. Okay, let's go off the record. Is this Mr.?
That just needs a signature. I don't see that he's here yet.
No, this is. What did I? Oh. I signed it. I did this. I signed it.
Okay.
So I
He
signed that
just
last
gave me
week.
that, so maybe.
Okay, I don't know where it came from, but I signed it last week and I was told to sign it.
Okay, I don't have.
Is he on the
notice
docket?
to show. He is. He's
Oh,
scheduled for
his attorney's here.
10:45, so maybe he is.
Okay.
I just didn't see him on the check-in list.
Yeah, no, his attorney's here. But let me give,
Is he in?
I don't,
Wasn't sure if he.
I don't know if he, I don't know if he posted bond.
Okay.
I believe he did. I know he's not in a red file, but I know we're short on red files, so. I know we have met, warrants to call. I'm going to finish reviewing this other, search warrant I have. If that's okay with you.
And then I left the 3 dates here with an elastic on, just so you know.
All right, well, they await another contestant. Let's go back to Judge Wheeler in Battleground.
Sir, can I have you state your name and date of birth, please, for the record?
Matthew Lawrence King, November 4th, 2003.
Mr. King, you're making a first appearance arraignment on a charge of failure to transfer title within 45 days. It's a simple misdemeanor, subject to 90 days in jail and a $1,000 fine. Before we proceed with the arraignment, there is an offer that's been handed forward in your case to amend the criminal charge down to an infraction called failure to register vehicle. So it'd be a $150 fine and a $150 filing fee. So total cost of $300. It would resolve the case today. Doesn't necessarily fix the underlying problem, but it would resolve the case today. So rather than proceed with the criminal arraignment, would you like the court to amend your charge to the traffic infraction?
Yes, please.
Okay. We're going to get you some documents, sir, over at the far desk by the door. And once you have your paperwork, you are free to go. Thank you.
Yes, sir. Thank you very much.
Yep. Alicia Falk. Try to maybe put those put them in order underneath them. Yeah. Well, ma'am.
Good morning.
Can I have you state your name and date of birth, please, for the record?
Alicia Falk, July 19th, 1989.
Ms. Falk, you're making a first appearance arraignment on a charge of driving while suspended in the third degree. It's a simple misdemeanor, subject to 90 days in jail and a $1,000 fine. In your matter as well, there is an offer to amend that criminal charge down to an infraction called failure to display a license. The $150 fine and $150 filing fee, it would resolve that case today.
Yes.
Okay, so rather than proceed with the criminal arraignment, would you like the court to amend it to the traffic infraction?
Yes, sir.
Okay, I will do so. I'll find the infraction committed. There isn't an associated traffic ticket that's also with the case. Let's take a quick look at that. It is a transfer without application infraction. Looks like that is a $1,000 fine. Madam Clerks, is Ms. Falk eligible for a deferred finding on her infraction? She does not have a CDL. So Ms. Falk, a deferred finding is a $150 fee. If you pay that fee, your infraction would be dismissed. You can use it once every 7 years on a moving violation, once every 7 years on a non-moving violation. This would be a non-moving violation. Would you like the court on your infraction to enter a deferred finding?
Yes, sir.
All right, I will go ahead and do so. So we're going to get you some documents, ma'am, over at the very far desk by the door in a few minutes.
Okay.
About how to get these infractions paid. And once you have that document, you are free to go. Thank you.
Thank you. Have a great day.
You too. Joseph Masick. Hello, sir.
Hello,
Can I have you state your name and date of birth, please, for the record?
Joseph Masick, 10/25/1985.
Mr. Masick, you're making a first appearance arraignment on a charge of driving while suspended in the third degree. That charge is what is called a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. It's also kind of a unique charge because if you're convicted of it, it carries a 1-year license revocation, meaning if you're convicted of it, you don't have no lawful way to drive. I did review the associated police reports with your case. I did from what is called probable cause. I had one question about your declaration here. Did you just start your job in regards to the
I
pay?
did just start my job. I'm almost at the end of my second week there.
Okay. How long had you been out of work before then?
I'd been self-employed.
Okay.
And it just wasn't working out, so I went and found a job.
Okay. Without getting into too many details, for your self-employment, every 2 weeks were you earning more, or sorry, every month were you earning more or less than about $1,400?
Every month I was making more than $1,400.
Okay, and you support 2 people. I'm going to go ahead and assign counsel, though. Court will assign. Court will assign Greg Cheney. So, sir, we're going to enter a not guilty plea today that preserves all of your rights and keeps all of your options open. I'm going to set 2 future court dates. The first is what is called an attorney pretrial date. That's just going to be for your attorney on the 8th of April.
Okay.
Your next mandatory court date, sir, is going to be on the 30th of April, 2026 at 10 a.m. You can be in person that day or on Zoom, but you do need to be present. Your release conditions are to violate no laws, appear at all mandatory court dates, to notify the court of any change of address or phone number. You are not to drive without a valid license and insurance, and I am releasing you on your recognizance. So your attorney can be in touch with you. Is there a phone number I can write on the form here?
Yes, 564-2.
Mr. Masick, we're going to get you some documents at the very far desk by the door. I then want you to go to the same location where you checked in for court. There's a table on the left-hand side. Get a business card for Greg Cheney. Call his office tomorrow. Let him know he's been assigned as your attorney, okay?
Okay.
Thank you. Skylar Thorpe. Hello, ma'am.
Hello,
Can I have you state your name and date of birth, please, for the record?
Skylar Thorpe, October 14, 2002.
Ms. Thorpe, you're making a first appearance arraignment on a DUI charge. A DUI is a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. It's also a charge, that has mandatory minimum jail time, license suspension, high-risk insurance, those sort of things if you're convicted. I did review the associated police reports with your case. I did find probable cause. Because this is a criminal charge, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. You're kind of on the borderline, but due to the nature of the charge and your age, I am going to go ahead and assign you counsel if you want a public defender. Court will assign. Court will assign Kenneth Wallace. Mr. Busby, on Ms. Thorpe's case, is the city asking for release conditions?
City's asking for standard DUI release conditions, no consumption of alcohol, non-prescribed drug.
Okay, so Ms. Thorpe, we're going to enter a not guilty plea at this time that preserves all of your rights and keeps all of your options open. I'm going to set 2 future court dates. The first is just for your attorney, Mr. Wallace. That is going to be on the 8th of April, 2026. Your next mandatory court date, ma'am, is going to be on the 30th of April, 2026, and you can be in person that day or on Zoom, but you do need to be present. That's going to be at 10 a.m. Your release conditions are to violate no laws, appear at all mandatory court dates, to notify the court of any change of address or phone number. You're not to consume or possess any alcohol, non-prescribed drugs, or controlled substances while your case is pending. You're not to drive without a valid license and insurance. So Mr. Wallace can be in touch with you. Is there a phone number I can write on the form here?
360.
So Ms. Thorpe, we're going to get you some documents at the far desk by the door. I then want you to go to the same location where you checked in for court, get a business card for Kenneth Wallace, call his office tomorrow, let him know you've been assigned as his client, okay?
Thank you.
Thank you, ma'am. Heather Contreras. Hello, ma'am.
Hello.
Can I have you state your name and date of birth, please, for the record?
Heather Contreras, and it's November 23rd, 1969.
Thank you, ma'am. Ms. Contreras, you're making a first appearance arraignment today on a charge of driving while suspended in the 3rd degree. That is a simple misdemeanor subject to 90 days in jail and a $1,000 fine. There is an offer in your case to amend that criminal charge down to what's called a traffic infraction. That traffic infraction is failure to display a license. The $150 fine and $150 filing fee. Rather than proceed with the criminal arraignment today, would you like the case amended to the traffic infraction?
Yes, please.
Okay, we'll find the infraction committed. There is also an expired registration ticket, it looks like, with the case. Let me take a quick look at that. Is Ms. Contreras eligible for a deferred finding, Ms. Travers? I guess it depends on when it was revoked in 19 then. Oh, we're close. Okay. So Ms. Contreras, the traffic infraction is a $242 fine. The court can mitigate that, which means lower the fine and cost for you. Would you like the infraction to be mitigated?
Please.
Okay. I'll find that that infraction committed. I'll mitigate it to a $100 fee.
Thank you.
You're welcome. So we're going to get you some information, Ms. Contreras, at the far desk by the door about how to get both of the infractions paid. Keep in mind, it doesn't fix the stuff, but so hopefully that gets taken care of soon, okay?
Okay, thank you.
Thank you, ma'am. Have a good day.
All right, let's go back to Judge DiSanto, and we'll finish our day off with her.
Well, 30758 on behalf of the Lee. Ms. Lee, would you please put your name on the record?
Hi, my name is Jessica Lee.
All right, and good morning. Today is the date scheduled for the arraignment pretrial on this matter. After a,
You want to, while you're, I left her notes. Ablitt.
okay.
Oh, that's. Apologies. Okay.
You're welcome.
Please put your name back there.
Your name for the record.
Jessica Lee.
Very good, thank you. All right, counsel?
Your Honor, John Goldwell, as to the arraignment, he should stand due to the charges, waive a formal reading of those charges after the plea of not guilty.
The court will waive the formal reading and enter a plea of not guilty for purposes of the arraignment. And as to the pretrial.
As to the pretrial, Your Honor, I've had an opportunity to speak with Mr. Mohammed. It's my understanding that in return for a plea of guilty to no operator's license on possession, the driving while license suspended second and first would be dismissed. I've explained to Ms. Lee her constitutional rights. She understands those constitutional rights. Also understands that by entering into this plea, she'd be waiving some of those constitutional rights. With that said, Your Honor, she wishes to avail herself of this plea opportunity. There are no immigration.
Okay, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, gentlemen.
Okay, you heard the plea that was placed on the record, correct?
Yes.
As to that amended plea of no operator's license on person, how do you plead?
I plead guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes, gentlemen.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, gentlemen.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, gentlemen.
And you do understand that this will abstract on your driving record. There may be some licensing sanctions. Do you understand that?
Yes.
Knowing all of that, do you want to continue with your plea?
Yes, gentlemen.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
All right, thank you. And counsel, if you can please ready your client.
Thank you, Ms. Lee. Back in October. Mr. Quarter floating around here.
October 18th. It's
October 18th of 2016. Were you operating a motor vehicle in the city of Wyandotte?
Yes.
And did you come a point in time when you came in contact with the Wyandotte police officers and they asked you for your driver's license?
Yes.
And at that time, you did not have a valid operator's license on your possession, did you? Then satisfied, Your Honor.
The court is also satisfied The plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And, counsel?
As to sentencing, Your Honor, we asked for immediate sentencing in this particular matter. Ms. Lee, at the time, was going through a very tumultuous time in her life. She was homeless. She was in a very destructive relationship. She was an abused individual, and that individual is no longer free to walk around. I'm not suggesting that was not, it's not an excuse for failing to appear quite some time ago, but that's what was going on in the life at that time.
Okay.
She has taken care of the matters. She has a valid operator's license at this time. There were, as I said, extenuating circumstances. She apologized to the court for not handling this, but unfortunately, that was not her priority at that time. Over the years, one thing led to another, it slips away. Now she's here before you. So,
Okay.
we ask for costs and fines.
All right. And your license is valid now, correct?
Yes, John.
All right. $100 fine. $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50. Well, I'm sorry, 150, I'm sorry, there's a warrant fee, right?
A warrant and clearance fees of 95.
Okay. And then a warrant fee of 50. Clearance fee 45 for $12.95 extra dollars. And so then that's $425. So the total is $520. Okay. You did post a bond of $500, less the 10% retention is $450. So you would owe $70 today.
I could pay whatever I have to pay.
Okay. All right. Just have a seat and somebody will be with you shortly at the window. Okay.
Thank you.
Good luck to you, ma'am. Thank you. Have a good day. Okay, let's go off the record for a quick moment. Mr. Gopal?
Okay, friends, that's the end of it for today. Well, not for today. We'll be back tonight. Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. Do join us there. Bring your talking points with you because the chat is in control of what we discussed tonight. So check us out then. And we'll be back here tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you are a channel member. So go have yourselves a good Thursday. Look forward to seeing you all soon. And thanks for spending your time with me this morning. Take care. God bless.